Good morning, everyone. I'd like to call to order this meeting of the Texas State Board of Examiners of Professional Counselors. Today is Friday, September 9th, 2022. It is 12 after 9. We're meeting today via Zoom and here in Austin at the new George H.W. Bush office building. Before we call roll, I want to bring everyone's attention to a couple of agenda item changes right here prior to the meeting. First of all, I want you to take note that number 9, discussion and possible actions related to solar proposal for decision. That has now been moved right behind number 4. So again, please note, agenda item number 9 will now be heard between numbers 4 and 5. The parties are here in person, and we're going to give them the opportunity to speak at the beginning of the meeting, so they do not have to sit through the whole thing if they choose not to. One other item, and all the public that's online, pay attention to this one as well. In the interest of hearing from the public, in the interest of hearing from our stakeholders, we're going to split up public comment. Now, if you will make a note between items 10 and number 11 on rulemaking, we will have public comment related to rulemaking only. This is agenda item number 11, new 681.140 and amended 681.147. Again, we will have general public comment at the end under item 16 where it's scheduled already, but we're going to do a separate split public comment so that we can hear from the public and from our stakeholders prior to consideration of the proposed rules. Okay, so 2 agenda item changes. Once again, number 9 is now between 4 and 5, and we now have, we'll call it 11A. 11A is public comment regarding rulemaking. Is there any questions on that? Hopefully I made that clear. All right, thank you. Apologize for the changes, but we are just trying to run an efficient meeting, and regarding the rulemaking, we did want to hear from everybody prior to our discussion. Okay. That being said, I think we're ready to get started. My name is Stephen Hallbauer. I'm the chair. I'm a public member. Dr. Taylor, please introduce yourself.
Dr. Christopher Taylor, Vice Chair.
Dr. Amuna, please introduce yourself.
Dr. Amuna.
Dr. Bradley.
Dr. Loretta Bradley, professional member.
Ms. Janie Stubblefield.
Janie Stubblefield, LPC Supervisor, professional member.
Ms. Brenda Compagnone.
Brenda Compagnone, professional member.
Thank you. And Ms. Vanessa Hall.
Morning, Vanessa Hall, public member.
Thank you, everyone. Madam Board Administrator, I believe that we have a certified quorum.
Okay.
I will hand it over to you for roll call on staff.
All right, so we have Patrick Hyde, who's the general counsel for BHEC, John Bridges, who is taking on one of the LPC cases today, one of our attorneys. We also have Kenneth Long, who is another LPC attorney. We have Brenda Skiff, who is the administrator for executive director of BHEC. Miss Victoria Benitez is another LPC attorney, and then we have Tim Spear, who is the operations manager, and myself, Christina DeLuna, board administrator.
Thank you. Board, we have one last time to review written minutes. This will be the last time we do it. Please take a look at our meeting minutes from May 6th, 2022. Once you've had a chance to review them, I will entertain a motion to approve these minutes.
Mr. Chair, I'd like to make a motion to approve the minutes as written as the final minuting of the
I
minutes.
second.
Thank you, Dr. Bradley, and thank you for the second. Oh, thank you for the motion, Dr. Taylor. All in favor of approving the May 6th, 2022 minutes, please raise your hand. And the minutes are approved.
Thank you.
Board, hang with me on this one. Following the May 24th shooting in Uvalde, hundreds, if not thousands, of Texas LPCs stepped up in response. It's impossible to recognize all of them. Most of them we don't know about, but everybody has assisted in the response effort in some form. A few that I would like to recognize and start with our own Dr. Taylor. He was interviewed on WFAA in Dallas a few days after the tragedy. Dr. Taylor explained what resources were available to anyone that needed some assistance, processing, understanding what happened, new anxieties, new fears. He was on and he spoke directly to the citizens of Texas on behalf of all LPCs. He did a fantastic job, and I hope people listened to what he said and then went and sought the assistance that they need. Board member Brenda Campanone is currently providing individual and family therapy for families in Uvalde. Those that have endured a loss, those that have survived. She notes that the town is still hurting, understandably. Ms. Campanone travels to Uvalde 3 days a week. That's an incredible way to be of assistance. And Ms. Campanone, thank you for doing that, for continuing to do that. TCA gathered a roster of more than 75 LPC volunteers that were willing to help out. Specifically, Paul Flores, a TCA member and Uvalde resident, helped connect this volunteer roster to those who were coordinating services on the ground in Uvalde. Thank you, Mr. Flores. Also, this volunteer roster went to Monica Gutierrez, who is a retired school counselor who worked with the school district to deliver these services. Thank you, Ms. Gutierrez. Mary Libby is the director of counseling in Northside ISD. They had their crisis response team on site immediately following this tragedy, and they remained there for weeks after. They are still providing responsive services and support today. Thank you, Ms. Libby. Adriana Phelps, also with Northside ISD, was at the Uvalde Civic Center the week of the initial response. She continues to go to Uvalde as needed to partner with the district LPCs and counseling teams. Thank you, Ms. Phelps. Finally, Sarah Martinez is with Communities and Schools. She was also at the Civic Center with Ms. Phelps. She was on campus sites for summer school, and she is the CIS leader for Uvalde CISD for this coming school year. Thank you, Ms. Martinez. Like I said, hundreds, if not thousands, of LPCs stepped up after this, and they continue to assist the residents of this state. We're grateful for everything that they are doing. I know I've missed many. I did want to recognize a few. The board appreciates what you're doing. And as a public member, the citizens of Texas appreciate what you're doing. As far as what the board can do in response, over the summer, I spoke with Daryl, and I said, can you get me a list of what is possible? What can we do that can help in this response? I know that Psychology Board has undertaken many changes that they would like to see. Daryl will be monitoring what psychology does. He's going to let us know this is an idea that came out of their discussions. He's going to take a look at the rules. Of course, we do not want to water down our high standards for our Texas LPCs, but I can't sit here and not do a thing. We have to see what is possible to help not only those that are hurting right now, but how do we stop this? How do we intervene in the future? Can we do more? I think we can always do more. We have to try. So that being said, thank you for listening to this. Board members, anyone specific that you would want to mention? Someone that I may not be aware of, someone who's really stepped up and is helping in the response effort over these past few months.
Brenda, I did not know that you were going to Uvalde to do that. Thank you very much for that.
I am. I travel out there to and from 3 days a week. That hit home for me. And so I felt like I could make some time and do what I needed to do to get out there. As our president said, it is extremely difficult, and I don't mind admitting that there are times when I drive back and I cry. You know, I am made of flesh and blood, and so it is difficult for me to hear a lot of the details, more so than anybody really has. I've heard them now. And so all I can say is really the only way we can continue to support them is to remember that this little town is still hurting, that they still need people like ourselves to be out there for them, hoping and praying for them to continue to receive funding for resources. But it's hard to explain unless you go there in person. It's hard to explain how you walk into a restaurant or you walk into a store and there's no smiles, there's no laughter. It's absolutely quiet. And you can feel that. You can feel the pain everywhere. It's still just a quiet town. You can see traffic passing to and from, but there's just no laughter. And it just continues. And so I know that, there's news every day, and then that's replaced by other news and other news. And I don't want that to happen to this tragedy or any other similar to that. I want us to remember that there was something that happened there that happened before and before that. And at some point, it just needs to stop. So whatever support you feel personally you can give, it really helps that little town out, and everybody else who has traveled from Florida, traveled from so many places that I have been able to meet. And it's amazing, but a big shout out and a big hug to all the parents that I've met. Those are the real heroes. The ones who still wake up every morning, the ones who are still taking their kids to school. It's hard. It's hard to see that every day. So just keep them in prayers. And again, whatever you can do to support personally, behind the sidelines, continue doing it. Don't forget.
Thank you.
Thank you.
Brenda.
Mhm.
Brenda, do you know, or does anybody else know of a formal nonprofit that anybody could donate to if they'd like to?
I don't know of a nonprofit. I only am aware of the agencies that are out there that are also providing similar services, like Hill Country. Strike, I believe, has a huge contract for the children. Uvalde CISD has also hired a few LPCs to continue providing the counseling, but in terms of somebody you can donate, I know they've got this big fund that they've been donating to, but I don't know exactly how that works. But school supplies and all these let me tell you something. I didn't want to get into this because I didn't want to cry about it, but I will tell you this. What is the saddest thing is that you have these families who have lost their children and they're at the brink of becoming homeless, if not they're already homeless. And that's because they've shifted and readjust their lives because the surviving children cannot go back to school. And so they're having to cut back on their work hours. And so they're not able to make mortgage anymore. So I have met 3 families who are now homeless because they refuse to leave their children at home because that is how much trauma there is in Uvalde. And see, those are the things that nobody hears about. Nobody hears about that. But I deal with it, I see it, and it's the saddest thing. When we are trying to give out gift cards to HEB and doing everything we can so they can have gas and groceries. So I think people need to know that you not only lost your child, but now you're homeless. And I don't think we should just forget about that. I think we need to think about that. We really need to think about what's really happening there that we're really not hearing about. And I'm going to get off my soapbox because, I've said enough.
Carol, are we allowed to, I know we have to be careful as far as like formal associations or whatnot, but are we allowed to put something on the website to say like, if you would like to give to a cause, like you can go here or something?
I don't know. I'm sorry. Go ahead.
I would caution against it because it looks like anybody you list, it looks like you're favoring that individual. It kind of gives the impression of the government's favoring this one charity or individual over another. So what I'm trying to do is while y'all were talking, I'm looking, I know there is one that I think Abbott's office had mentioned in a press release. And I'm like, if I can find that would be something we could use. I just can't remember the name of it.
Daryl is actually, if you go to the texastribune.org, there is a quote in here from the governor and a phone number. It's an 888-690-0799 number that is listed, and it's a helpline. If you're looking to help to provide resources, counseling, and all of this is according to the governor's office. Again, it's texastribune.org. When you pull it up, it's going to say, here's how to help Uvalde shooting victims, survivors, families. And you'll see a quote from the governor, and you'll see the official resources that is listed.
That's wonderful. Can we post that on the website and then send out an email blast as well to everybody? That'd be great.
I'm looking at texastribune.org just for anyone's information.
Vanessa, can you send me a link to that article that you're looking at?
Yes, sir.
It'll save me from having to hunt through the Tribune's website.
Sure.
We'll try to get that up today, Dr. Taylor.
Okay, I just sent it to you.
Thank you, Vanessa.
You're welcome.
Got it. Thank you, ma'am.
Sure.
Thanks, everyone. We're going to go ahead and move on now. As we discussed, agenda item 9 has now been moved up to after item 4. This is discussion and possible action related to a sole proposal for decision and default dismissal order and possible orders to be recommended or ratified by the board. And you wanted to
Yes, if I
Sure.
could just leave my share, like we talked about earlier.
Yes, I am gonna have Attorney Bridges present the matter before you speak, and then
Am I in the right location?
You can scoot back just a little bit more.
I will scoot over. Please.
Oh,
There you go.
oh, there, okay, now I see.
Okay. So, John, will you present this item and explain what we are deciding today?
Yes, sir. Esteemed board members, two complaints were filed against the LPC Associate License of Shannon O'Connor alleging sex with a client. It went to an ISC. Dr. Stubblefield participated, so she should abstain from any vote that is taken. It then proceeded to SOA.
As long as-
The facts were heard. A proposal for decision was returned. Counsel for Ms. O'Connor requested amendments be made, and an amended proposal for decision was returned that recommended revocation. And I have prepared a final decision in order for the council to ratify, but for y'all to consider if you wish to take it in form or if you wish to make amendments.
Ms. Stubblefield, what was your official recommendation? Do you recall?
Okay, one point of clarification, Mr. Bridges, thank you very much for providing me that doctorate. I am still
Oh,
all but dissertation, so. um, uh, Christina, what am I allowed to say? I know I was supposed to recuse myself, so.
Yeah, that's
Yeah,
gonna be
or
something
Daryl.
passed to Daryl or Patrick.
Yeah,
Daryl, Patrick.
you really can't have any part of the discussion, Ms. Stubblefield. Yeah,
It's a
you're,
Public document, guys. I just want to know what her recommendation was.
I'm sorry, the recommendation was for revocation.
Thank you.
Okay. Daryl, Patrick, does Janie have to leave the Zoom or she just not participate?
she just refrain from participating.
Okay. We have counsel here. They have been allotted 10 minutes to speak on this matter. It's my understanding that no new material can be presented. You do have the file in your meeting materials packet. Patrick, can you give a notice when there are 2 minutes remaining in the 10 minutes, and then a second notice when there are 30 seconds remaining in the 10 minutes? Will that work for you, counsel?
Yes, yes, thank you very much. Thank you, Patrick, for doing that.
Okay. Counsel is Attorney Laurel Clement, and I will hand it over to her. She's sitting right next to me.
All right, well, thank you so much. It's such a privilege to be here in person. It's been a long COVID time since I've been able to see many of y'all in person and present to the board. This is a little bit different than I'm used to. But I'm happy to be here. And I do want to compliment BHAG, John Bridges, the attorneys I've worked with have been excellent, have been really advocated for the board and have done an excellent job. I, however, have differences with the ruling for revocation, and I want to talk about that. I want to talk about 3 different things: substantive due process, similar cases with different results that has been under BHEC. And I also want to talk about the 3 reasons for the government to sanction someone. First of all, I'll talk about substantive due process. As you know, giving a license to somebody is a property right. They are entitled to both procedural due process and substantive due process. I do not believe the substantive due process has been met. There was no showing of past harm at the SOA hearing. There was no one from the facility where Shannon worked. There was no evidence of any contact with the gentleman that was involved. And there was no showing at all of any harm that had been done. So I think that the lack of harm for her action, I think they absolutely missed the mark on that. As far as future harm, if you read through the materials, I did have an expert testify. Jeffrey Fletcher is one of the handful of psychologists or counselors that are allowed to testify in deregistration hearings with criminal cases. So what that means is if someone is ordered because of a criminal violation to register as a sex offender, there's only about 17 people in the whole state that can evaluate and recommend that the person no longer have to register as a sex offender. That is a very high bar. So he is very qualified. The state obviously depends greatly on his decision and his recommendation. And I think if you look back in your documents, you will see that he found that there was a low risk for any sexual violation by Miss O'Connor. Of course, he can't say no violation because his malpractice carrier wouldn't allow him to do that. Since that time, since the offense has occurred, Shannon has been practicing for almost 2 years, and her practice has been online only. So she has no physical contact with any clients. Part of the package that we've put together and have recommended to the board consistently is 10 years of probation. The fact that Shannon needs to continue online only, and she needs to obviously practice under a practice monitor, get more CEUs than the average LPC would do. I also want to mention the similar cases with a different result. We did talk about one particular case in our testimony. It actually was a case that I handled in front of BHEC. It dealt with sex with a client and it was dismissed. And the reason it was dismissed is because they got married. The LPC and the client got married, and so it was dismissed. I also am aware of 3 different cases that deal with sex with a client or sexual contact with a client that have different results of probation. 2 years probation on a case that was July 2021. Probation of 8 years, June of 2021. And June 2021, another case with probation, 3 years. So why is it that Shannon's case is considered more severe than the other cases? Why is it we're handling that case differently? I would want to review with you the reasons why we sanction someone. I also, when I was younger and had much more energy, got a master's in criminal justice. What I learned in that program was about why different places do punishment and what are the reasons that we administer punishment. So the 3 main reasons are what? Exclusion from society, rehabilitation, or as a deterrent in the future. So what I want to talk to you about in exclusion from society is the fact that, yes, if you took Shannon's license away, she would not be allowed to practice, but she's been practicing for 2 years. So I'm not really sure how you're going to say or show that there is a danger in allowing her to practice when she's been practicing for 2 years. Rehabilitation is usually the second reason where there's some sort of sanction by the government, whether it be prison, jail, taking away someone's license. Obviously, if Shannon were to be placed on probation, that would be an opportunity to rehabilitate her. She was 25 years old when she committed this particular offense and has an opportunity to be rehabilitated or has been rehabilitated, and an opportunity to contribute to the need for mental health services in Texas. In addition, deterrent. I do want to touch on that. First of all, when you have differing results for the same offense, you really lack deterrence. In addition, crimes of the heart, we know deterrence really doesn't work well. Deterrence works better with financial offenses where people have to make a decision about whether they're going to commit that offense or not.
2
Crimes
minutes.
of the heart, thank you. Deterrence does not work. I'm going to turn it over to Shannon at this time.
Good morning, everyone. Thank you, Laurel. Thank you, everyone, for hearing my case today, giving me the chance to speak. To say that I'm deeply ashamed to be here today would be an understatement. I'm here because I fell in love with someone I shouldn't have 2 years ago when I was 25 years old at a time of loneliness and isolation caused by a global pandemic. I was conflicted about my feelings from the start due to my professional code of ethics, and I never meant for this relationship to take off the way it did. If I could go back in time and change the past, I would. Since ending the month-long relationship with my former client, I've taken every effort possible to remediate myself in the eyes of the board. I've completed over 30 hours of training on boundaries and ethics, and I attended 4 months of dialectical behavioral therapy. I even moved away to a different city. The past 2 years have been a painful journey of soul searching and trying to forgive myself for what I've done. I got sober on February 21st, 2021. I obtained a sponsor. I completed the 12 steps of Alcoholics Anonymous. And today I still work with that same sponsor. And I sponsor other women. I've been employed with the same company for 1.5 years, providing online intensive outpatient services to other alcoholics and addicts.
30 seconds.
Yep, this platform makes substance use counseling accessible to people in rural communities who otherwise wouldn't have access to this resource. And I am so grateful that I've had the opportunity to do this important work. I pray that the board will allow me to continue providing this service. What I did 2 years ago was a violation of ethics, and I want to show the board that I am willing to do anything to keep my license so that I can continue helping people the way I do now. And I hope that today you see a changed woman in front of you, and thank you all for your time.
Thank you, Ms. Tom.
Thank you.
I don't know if there was questions or.
So we're gonna have board discussion on this. I'm gonna start off, Mr. Bridges, if possible, can you give us sort of an explanation regarding, I know there's a due process claim here. Can you sort of explain how that was addressed in the response?
The judge found that all considerations had been made that needed to be made, and that every opportunity for the respondent to speak had been given.
The argument here, we failed due process because of did not consider the harm analysis. Is that, what is your position on that?
As everyone here, experts know that sex with clients is harmful. That is why the rule is as strict as it is.
Okay.
May I respond?
Yes, you may.
The court has specifically reversed cases where there is not a consideration of the punishment to be considered. I will give you the case, Ex parte Brown, 158 Southwest 3rd, 449 from 2005. Ex parte Brown, 158 Southwest 3rd, 449 from 2005. What that case says is just because a judge told somebody, if you come back in front of me, I'm giving you 20 years. The person came back before the judge. The judge said, I'm giving you 20 years because I told you I would. And the court said, you absolutely cannot do that. You absolutely have to weigh every single case. And just because it's a section or station level 1 revocation, the court will not put up with that. The court is not gonna go along with the argument that because it's a sanction 1 case, that's an automatic revocation. Please read that case.
But those facts weren't the only facts considered by the judge. It was also considered that the supervisor of Miss O'Connor, who is one of the complaints filed, didn't see a need to remediate her because Miss O'Connor's first reaction was to lie and try to cover up. You're trying to compare apples to apples, but this is apples and oranges. Every case has different facts.
Right, John, but what I'm saying is if you are standing on the belief that because it's a sanction 1 violation, the court is going to reverse that. All right, you've just given us a whole different argument. I was giving you a comment regarding your sanction 1 violation.
I don't understand what they're trying to get at. It is known that sex with clients is harmful. And as for the actual punishment, why revocation? She lied.
I'll
I'll
tell y'all, I think we're probably getting a little bit of a skew of kind of the function and purpose of this hearing today. I'm not saying you can't make these arguments, but we're not really here to discuss whether or not the board has the ability to recommend revocation, because they obviously do. I think what Ms. Clement is saying is that maybe we don't have a factual basis to do so. I don't think there's anybody that can say you don't have the legal authority to do it in this case. It's just, I think what Ms. Clement is saying is without some type of showing of harm, you can't do it. Now, obviously, Mr. Bridges and Mr. Hyde and myself, we respectfully disagree with that because we think that there are other facts involved here. But what I don't want to do is get us hung up in all the lawyers arguing whether we can or we can't, because really the decision boils down to, what do y'all think that the ALJ has found that there's a violation, and that it's a violation that under our schedule of sanctions would warrant a revocation. So now the ball is in the board's court based on what you hear today from Ms. O'Connor, Ms. Clement, any other witnesses that they've got.
Right, and please be aware that I still have the ability to appeal this to the district court. So,
Right. But we can't, I mean, that can't really factor into our decision. So anyway, we got to look at the record that's before us. You got an ALJ with a PFD that's recommending revocation. You're not bound by that recommendation. But I think you got to look at what's in that PFD that supports that recommendation. And if y'all agree with it, then you got to make your own recommendation there. So.
Professional members, questions for either Ms. Clement or Ms. O'Connor. Dr. Muna, I'm not going to put you on the spot, but I do know that your academic expertise is in this area. Is there anything that you would want to ask about?
Not anything specific, as a newer member to the board, but a senior clinician, I did go through the audio of, I think, 3 hours of audio. I went through the entire packet from both sides. So I just want individuals to know that I am informed because I went through all of it. And I'll just say that there are some concerns that I have, but one question that I have would be, I understand that when we are working with individuals, we can cite exceptions to rulings, like this was done this way, this was done that way. But again, as a newer member of the board, my first thought process is to the ratio. So of all the individuals who have come before the board in general, that have come before the board with this offense, I know that we can pull out the exceptions, but what are the individuals that came before the board with a similar offense and it was a revocation? Like if, again, I don't expect you to have that magic number, but if it's, hey, we had 10 cases and 3 were exceptions and they were not revoked, that's a big quantity for me to consider. But if we've had 100 cases of the similar offense and only 1 was not revoked, then that's kind of telling to me for the history and the way that the board has generally voted on these issues, given the quantity of information that's already provided on this case with the audio.
Well, what I can say is I've been doing LPC cases for 18 years and I have never seen a revocation before. I've never handled a revocation. I follow the board orders, obviously, and I've never seen a revocation.
Ms. Clemens, I have revoked several licenses for this reason.
And Dr. Muda, to your point, I don't know if we have a way of knowing this all, like how many like what you're asking for a percentage. I don't think we have that data, but to Dr. Taylor's point, we have revoked some and there may have been some that there's allegations made that we may have dismissed because we couldn't prove something for whatever reason. I couldn't tell you numbers and I'd only have to speak in general terms.
You got to remember, you also need to include resignations. And with resignation, it's the functional equivalent of a revocation.
It's not the same thing though.
It is for all practical purposes because it's an individual saying, I did that bad thing. I recognize that I'm probably going to get revoked on this. So I'm going to go ahead and bow out rather than having to go through the whole revocation process. And I signed quite a few of those. I mean, those you should have those in your board packets there. You should see those come across each board meeting, but I do know that I've signed several of those. There may even be one in your packet now. I don't know.
I was just getting ready to say as a board member, I know there have been cases, I can't tell you how many, but I know for these reasons, since I've been on the board, this is not the first case.
Thank you, Daryl and Dr. Taylor and Dr. Bradley. That was the kind of history information that I was looking for, just to have a more informed palette with regard to, again, the cornucopia of things that I went through with reading the packet and wanting to make sure that when I make a decision, it's informed. And so that's why I pour through all of the information that Christina so graciously sends to us.
Mr. Chair, I'd like to say a couple of things. The first is I'm glad I'm not an attorney, although I have a sharp tongue, but I'm not an attorney and I'm so glad for that. But I think the one thing I always think about in these situations is I'm in the here and now, and I want to look at her individual case only. I don't want to, reference anything else, any other cases, because that becomes confusing for me. I just want to give her 100% of my time, my thinking, where am I on this? And so I think what I wanted to ask was that I heard for her attorney, I'm sorry, and I didn't catch the name again.
Oh, it's Ms. Laurel Clement. That's fine.
Yes, ma'am. I wanted to ask you, you mentioned that there was no evidence of contact, like there was no evidence, but yet she did get 10 years of probation.
No, what my client and I are suggesting to the board is that she be given 10 years of probation for this.
Oh, I see.
offense,
Okay, okay.
Opposed to a revocation.
Oh, okay, I see. I see what you're saying. Okay.
And when I mentioned contact, I think what I was saying at that moment was, since she is now doing online only, and she has been for the last 2 years, online counseling only, she does not have any contact, obviously physical contact with clients. And we're certainly in agreement with having that as part of the probation package, that she continue online only.
And
Go
with
ahead, Dr.
counseling, you know, there's
Sorry.
times when you've got people that are gonna require in-person sessions, and so it's kind of hard to you limit a person to just online counseling, specifically when you are dealing with the diagnosis of psychosis or borderline personalities. It's just a whole bunch of things, but you did answer my question. Thank you.
Yes, and she works mainly with substance abuse issues. And works with people all over the state. The company she works for is an online counseling company. I think it's called Red Lion. Lion Rock. Lion Rock. Red Lion was a grocery store. When I was younger.
Dr. Bradley, I know you have a question. Go ahead.
My question is, in this person's training, did she, for example, have an ethics course along the way for her master's?
I'm sure she did. I mean, she went to Southwestern, is that correct? UT Southwestern for her master's program. I'm sure she had an ethics class that's required for every program.
Yes. And did that ethics course tell you that if you committed this behavior, that this is wrong, that it's against the codes of ethics, it's against the LPC and so forth?
Yes, I'm sure it did.
Okay. So what you're telling me is your client chose to dissipate training and laws, right?
Yes.
Go ahead, Dr. Amuna.
Just for a point of information, in the packet that I received, there's a series of text messages, and for Dr. Bradley, there's a series of text messages where I think there's a section, and I'm paraphrasing, forgive me, where the defendant says, you know, I think this could mess up my license, or I don't think that I'm supposed to be doing this because of my license. And so that's like, it's a clear, something in a screenshot text message from someone that is alleging that it's her. So I'll make sure I'm mindful with my legal words. Alleging that this is her having concern about her license in her correspondence with the other party.
Well, and that may be correct. I honestly don't remember, but that is why I'm saying that with crimes of the heart, deterrent does not work, because people know that they are doing something that they probably shouldn't do, and they still do it anyway. So that is exactly why I'm saying deterrence does not work with this particular offense. And especially when you have offenses where you just give probation. So.
Ms. Clement, if deterrence doesn't work, then why wouldn't we revoke her to utilize incapacitation? In other words, completely remove the ability. If we cannot deter this through a suspension or probation, shouldn't we revoke her? So that we make sure this never happens again?
Well, no, because she is rehabilitating. And that is why she's been continuing under supervision. That's why we are asking for 10 years of probation. So she continues under supervision for 10 more years. I mean, obviously, there's not going to be the risk. For instance, when she took the evaluation under Jeffrey Fletcher, who determined that there was a low risk of this type of incident in the future. I can't remember his exact words. But that with rehabilitation, with monitoring for 10 years, it's probably not going to happen again. And the question is, are you willing to do that? Are you willing to reach out and say 10 years of probation is something we are interested in?
Part of rehabilitation is admitting the harm that you have done. We at this point have heard no argument from you whatsoever that she admits that she did harm.
Well, she made a self-report. Her supervisor made a self-report and she made a self-report. Obviously, she realized at the very beginning that she violated the rules.
It's not about violating the rules. It's about admitting that you did harm.
I mean, I don't recall exactly what was involved in her testimony. I think you just heard her statement. I'm not sure what that means to you, but I would just rely on her previous statements to the court.
Go ahead, Dr. Miller.
So for me, one, I'll just go back and reference the text messages are in the petitioner's witness and exhibit list that was provided to us. And that it says modified December 9th, if that helps someone search through to see the text messages. But also in the audio, I do recall hearing, and I referenced the audio first to make sure that I said the right thing, that it was expressed that she did not self-report immediately when it happened, and that when she was immediately asked, it was denied. And she acknowledged it. I think someone said that I was afraid, which is why I denied it. But then after all the evidence was brought to the supervisor and a complaint was made, then there was a self-report. And so I think that part is concerning to Attorney Bridges' point. It's not, man, I effed up, let me self-report, let me see what I can do to get better. It was, I thought that I was caught, I denied it, the person, I'm still good at my job. And then, okay, all the stuff hits the fan, and now let me self-report.
Well, but why would someone self-report to lose their license? I mean, that doesn't make logic. Why would someone say, please take my license away? If that's what if that's what the end result is gonna be.
Again, this is about me, my license. At no point has it said anything about what was done to the client.
Well, you're exactly right, John. Y'all could have brought the client to be a witness. Y'all could have even talked about the fact that you had some contact with him. Y'all never provided any testimony at all that you contacted him by email, by phone, in person. He didn't come and testify. Y'all dropped the ball on that one.
So y'all are still requiring that he testify to say that that was harm, whereas you're refusing to admit that your client did harm.
I'm not saying that at all. John, I think you're mixing up my
Mr.
words.
Chair, if it'll please the board, I would like to stop the back and forth between the attorneys. I am happy to move forward on a vote. I have faith in Ms. Stubblefield's decision. I have reviewed everything along with Dr. Hamuna, and we have a decision from a SOA hearing, which to my understanding, and Daryl can correct me if I'm wrong here, I don't think we've ever reversed our decision once we've gotten a SOA decision. So I am happy to make a motion for revocation if you will entertain so at this time.
Okay, Dr. Taylor has made a motion that we uphold the proposed decision out of SOA recommending revocation. Is there a second to the motion?
I think Brendan.
Okay, Ms. Campanone with the second. Okay, we have a motion and we have a second. We can now have any discussion on the motion that was made. Daryl or Patrick or John, I just want to clarify that procedurally, we did get the specifics correct on what the motion needs to state before we vote.
Mr. Taylor, Dr. Taylor, is it your motion that we revoke Ms. O'Connor's license and adopt the PFD as indicated in the proposed order that Mr. Bridges has prepared?
That is correct.
Okay, and Brenda, you agree with the second on that clarification on the motion? Okay. Then we have a motion, we have a second. Is there discussion regarding the motion that has been made?
I have a question, I'm sorry.
Go ahead, Dr. Moon.
Was there a pathway for, and I kind of referencing Daryl's comments earlier, was there a pathway for the defendant to, what was the word, resign the LPCA with the opportunity to potentially apply at a later date versus having that revocation? Was that ever a path provided to her
Yes.
to avoid
Yeah.
that?
Yes, it was.
And it
The
was-
standard is a standard action that comes along with every case.
So okay, so that was an option to say, I'm gonna resign and maybe apply at a later time. Okay.
Is there any further discussion? Does Janie have to abstain from the vote? Okay. All right. We'll now vote all in favor of accepting the agreed proposal for revocation from the SOA matter. Please raise your hand. Okay, so that is all 7. So hearing no opposition, then the SOA matter is upheld.
Mr. Chair, I just like the record to reflect that Ms. Stubblefield did refrain or did abstain from voting on that matter. She was
My
recused.
error.
No, you're right.
6 in favor with 1 abstention.
Well,
Thank you.
It's been a privilege to present before you today. I really enjoyed seeing y'all and Patrick and Daryl, seeing you in person. I hope to meet John and Kenneth Long in person someday soon. So thank you very much for your patience, and I appreciate you taking this as seriously as I do and my client does. So thank you. Good to
Thank
see
you.
y'all.
And thank you, Ms. Stubblefield, for your dedication to that case.
Give us just a sec, guys.
Steve, can we just take 5 up there? For this coffee, maybe?
Yeah, let's go ahead and take 5. He's not here, so let's meet back at, what is it, 10:10 or no, 10:15? 10:15?
In the chair's absence, I will rule. We'll be back in 5 minutes.
Thank you, Dr. Taylor.
Thanks, everyone. We will continue now with agenda item number 5. Board review and possible action regarding application review or denial. 5A is Mr. Mario Kirk. Christina?
Good morning. Yes, Attorney Benitez will give you guys a brief summary about Dr. Kirk's case, and he also is on the call. So after we hear from Attorney Benitez, we can hear from him for the 3 minutes that he's allowed. So I'm going to throw it over to Attorney Benitez. Oh, you're muted. There you go.
There we go. Good morning. Dr. Mario Kirk applied for a license. He was denied a renewal of a license that lapsed in 2014 based on the following. He had 2 pleas of guilt for Medicaid fraud and identity theft in the District Court of Oklahoma, State of Oklahoma. In July, on July 18th, 2018, he pled guilty. He received a 3-year sentence, deferred and probated, along with restitution payments. His lawyer for that offense, who's not representing him here, has told us that he's eligible for dismissal now and to petition the Oklahoma court for expunction, but he has not given us any documents that show the case has been dismissed or that the conviction has been expunged, which is his obligation. Additionally, staff contacted the Oklahoma State Board of Behavioral Health, and Mr. Ashmore in licensure there advised that Mr. Kirk was allowed to let his Oklahoma license expire. We were notified, I believe yesterday, that he has now hired a lawyer to start the expunction or expungement procedure in Oklahoma.
Did the lawyer give any indication on when that is expected?
I do not know the expungement law in Oklahoma, but it appears his former lawyer said that he could get it immediately. That's not the case in Texas. You have to wait, I believe, 5 years. But certainly, if it were expunged, that would resolve the issue.
Okay. Anything further before we hear from Mr. Kirk?
Unless you have questions, no.
Mr. Kirk, we're going to bring you into the Zoom. And you have 3 minutes to speak. Patrick, please give him a 30-second warning. Go ahead, Mr. Kirk.
Can everybody hear me?
Yes, sir.
Okay, this is Dr. Kirk here. First, I would like to thank the board for considering my case. On August 24th, I forwarded an email from a Melanie Freeman Johnson, who is an assistant attorney general specifically from the Medicaid Fraud Unit Office. I don't know if anybody got that email, but that email specifically is from the very entity that prosecuted the case. And it lines out that I am eligible for expungement under a 991 expungement petition, which is immediate. I don't have to wait the 5 years, anything like that, because this is them specifically saying this. Since then, my former attorney, James Siderius, he became a judge here in Oklahoma. So my current counsel is Steve Hendrickson. That's the email that Ms. Benitez was just speaking of. So we're just beginning that process. But going back in time, I take full responsibility for what happened under my watch in my practice. I have gone many years, still working in the business, unlicensed. I learned a lot. I learned things of not to do. I learned better ways to practice, and I think I'm a stronger clinician for it. I think I'm a better person for it, having to, be humbled a little bit going through this process. I would like the court to reinstate my license so that I can get back into the helping profession on a license level. Everybody knows, it's more clinicians are needed, after pandemic and the incidents like Uvalde. It's just here in Oklahoma, and I've also lived in California. It's just mental health clinicians are so much needed.
30 seconds.
And if the board sees fit to renew my license, that would allow me to get back into where I'm needed and where there is so much to help feed, to help meet that need. Thank you.
Board, any questions for Dr. Kirk?
I have one, Mr. Chair.
Go ahead.
I know I'm not the board member, but Dr. Kirk, did I hear you right? Did you say you are still working in the business, just unlicensed?
Yes, sir.
Where are you working at?
Right now I'm working for a company called Solari. It is a Arizona-based company, but what they have the contract for the new 988 national hotline. I'm just we call it a crisis specialist. You know, I'm one of the people that answers the phones when you call here. And you know, that's very rewarding work. I mean, it's much needed. And here in Oklahoma, your 988 also was rolled into mobile teams, where mobile teams can go out to the community and see individuals where they are without having to call police for everything. So
You're physically in Oklahoma.
yes, sir.
Okay.
Ms. Benitez, did I understand that what we need is for him to complete that process of getting things expunged, and this will be resolved? Is that?
That would be 882.42D requires, it's a shall, not a may, the board to revoke a license if someone has been convicted of an offense that directly relates to the duties or responsibilities of a licensee. And that is exactly what the conviction is. So what I'm saying is I don't think the board has, it's a shall and not a may.
Go ahead, Dr. Amuna.
I was just gonna say, I've read through, I do have a life, I promise. I read through the messages from Melanie Freeman Johnson, and the reference to section 991C does speak of an expungement. It does mention that this particular charge is eligible for that. In my view, it seems like we're just getting a preview. Like if the defendant, if you came before us after this was done, it would be null and void for us to even hear it. Based on all the evidence that's been provided, is that you would meet all the criteria and eligibility. We're just hearing it early. And I don't know if there's something for us to actually do, but wait till it's done, because then you would be in a better position.
Let me ask something. Victoria, Patrick, I'm looking at 882.42D. That talks about felony convictions for Medicaid fraud. And it talks about unprofessional conduct. I don't see where it would apply to like a deferred adjudication, because it sounds like that's what this guy's got. Am I missing something here?
I believe he pled guilty to Medicaid fraud, and that's why in D1 it says shall revoke if convicted of Medicaid fraud.
But is he actually convicted of it?
I don't know Victoria, do you know?
We have not seen anything that says he's not.
That says he's not?
Right. We have in your packet, there's the information, there's the conditions of probation, but we have not gotten from him or anyone else, and it is his responsibility, a dismissal or an actual expungement.
Dr. Kirk, were you convicted in Oklahoma? Is there an actual conviction on your record?
No, here in the courts, it was a deferred sentence. The actual conviction of those 2 counts will be held off if I successfully finish my 3-year probation, which had a lot of different elements to it. 2 years supervised, 1 year unsupervised. I was also
Yeah, I got all that, but what I need to know is I need to know if you were convicted, because that's what really changes the nature of this discussion.
no,
Uh,
because
you don't have any of these records that you could send to us?
what I have is the email that I got from the Attorney General's office, and part of that email is me asking if there are, if there were some records that says dismissed or things like that. Basically, the instructions I got from the AG's office is that the expungement itself
Okay, but
serves as a dismissal.
I understand, but we're not there yet. I'm operating in the here and now, right now. And
So
I
to
don't want to,
answer your question, I do not have anything from the AG's office saying that it's dismissed. No, I don't.
because I honestly cannot tell from what you sent us whether you're on deferred or whether you were convicted. And I mean,
Daryl, would it help for us to either table this so that you can get that documentation, or for us to deny this because we cannot make a judgment based off of something that will happen in the future that may or may not happen in the future?
well, I certainly don't want to table it based on something that may or may not happen in the future, because for all I know, I don't know Oklahoma law, and I don't want to just leave this in pending.
Yeah, Mr. Kirk, unfortunately, we just cannot make decisions based on what might happen, tomorrow. So at this time, right now, a denial is, I think, what we have to do. And then once you have the expunction, then just come back and you'll be, I think, be able to start the process then. And and this will not even be on your record. So I'm happy to make that motion, Mr. Chair, if we'd like to move forward.
Okay, Dr. Taylor has made a motion that we deny.
I'll second.
Ms. Stubblefield has seconded that motion. Any discussion regarding the motion on the floor? Okay, hearing none. All in favor of denying Dr. Kirk's application at this time, please raise your hand. Okay. Any opposed? Same motion. Okay, seeing none. The denial is upheld. We would recommend Dr. Kirk take care of the legal matter and then come back to the board.
Okay, thank you.
Thank you. 5B is Janet Garcia. Christina, will you introduce us, please?
Yes, and to begin, Ms. Garcia, if you are on the line, can you please raise your hand in the Zoom function? I'm not seeing your name, so I just want to make sure I don't miss you. I know she did email this morning that she wasn't able to log in for a short time. And then the board members in your packet, you received some additional information from her yesterday as well, some communication that she had sent me. So this case, and I'm not seeing a hand raised, so I'm going to keep looking. But again, Ms. Garcia, if you are on the line, please go ahead and raise your hand in the Zoom function. And so this is an application that was reviewed by the committee, the applications committee. 3 of the 4 board members did respond that they agreed with staff in that sufficient information related to who provided the LPC, the continuing education has not been verified. So she's applying for supervisor status in Oklahoma. She holds supervisor status there. I don't know what their requirements are. I don't know what she had to submit to get the supervisor status there. But in Texas, we require the 40-hour supervision course, or the continuing education that she did should have been taught by an LPC supervisor. She's not able to prove that those courses were taught that continuing education was taught by an LPC supervisor. There's a lot of communication that's gone through that. You guys have everything that staff have communicated with Ms. Garcia about for this issue. So at this point, again, I'm not seeing her, I'm not seeing a hand raised. And you all do have all the information with all the communication we've had with Ms. Garcia. But at this point, the board needs to review to determine if the documentation that Ms. Garcia provided is sufficient to meet board rules, specifically related to the continuing education being taught by an LPC board approved supervisor.
Dana, you want to try that phone number and see if that's her?
Sure.
Yeah, I think while she's doing that, I think the rules are abundantly clear. I mean, it has to be taught by an LPC supervisor, and without being able to verify that from this platform, I don't know how it can be approved.
And I think it's also been made pretty clear to her that just taking that, like a Texas course, would allow her to take that next step. So
Caller, if this is you, you can do a *6 to unmute yourself. If this is you ending in 1558. If this is Ms. Garcia, please unmute yourself, and it's *6. Okay, I'm gonna try the second number.
That second one is a computer, Christina. That's
Oh.
not a, yeah, that's not a telephone number.
Okay, thanks. So I do not see Ms. Garcia here, and she did in her email responses say that she may not be here. There was another method that she was going to send you all. I never received it.
I don't see her. Stephanie Woodruff is not part of the Zoom, is she?
I can add her back on. Let me see.
I just thought she might have something to add.
But yeah, let's see. Where'd she go? Did she hang up?
She's got her hand
Oh,
up.
there she is.
Okay.
It went all the way back up to the top. All right, Stephanie, if you wanted to add anything related to this case. If you're on, we can't hear you. Are you there? We're still not able to hear you if you're speaking. Yeah, it looks like she's trying. And Stephanie had, lots of communication with her with Ms. Garcia by email as well, which is all in your packet. So if there anything that, she may need to share, you guys probably already have in the material. But if you had any specific questions, I can try and answer those, or I can go ahead and see if while Stephanie's trying to get that worked out.
No, Christina, it seems pretty direct to me. I can understand the frustration and why she would be so irritated. It is very frustrating to having taken a course and then find out that, it might not qualify for what it's supposed to. I was troubled a little by her email where she was saying it was our responsibility to go out and make sure that these courses were sufficient. And I'm sure everybody here knows this, but it is the licensee's responsibility to read the rules and navigate the rules properly. With that in mind, and the fact that the rule is very clear that the course must be taught by an LPC supervisor. Without verification of that, I don't see how we can approve the course at this time.
Are you making a motion, Dr. Taylor?
You know, I'm 2 in a row, so I'm happy to keep the streak going, but if somebody else would like to share the work, I'm happy to do that too.
How about we just reverse roles? Chair, I move that we deny this application without, as it stands. And should they take an approved course, then they can reapply.
Thank you, Ms. Stubblefield. Do I have a second to the motion?
I will second.
Thank you, Dr. Taylor, for the second. We do have a motion on the floor. Is there any discussion regarding the motion that we deny this application? To me, this strikes me as the second person who just needs to kind of finish something up and then come back and there won't be a problem. But that's how I view it. Is there anybody who sees it differently? Okay, then let's go ahead and take the vote. All in favor that we deny this, the application to supervisor, please raise your hand. Okay, that is 7. Seeing everyone voted in the affirmative, that passes. Moving on, we've got possible action on orders to be executed by the chair. I will confirm with our administrator that there are none.
There were none, correct.
Okay. Then let's go ahead and move on to orders from fiscal year 2022 third quarter.
Okay, so those were in your board packets. We had, let's see, 6 agreed orders and 1 eligibility order. And again, those have already been executed by the executive director.
Any questions for the executive director or the board administrator regarding any of these third quarter orders? Moving on, item number 8, reports. Christina.
Yes, so sorry, in your board packets, you have the Q3 performance measure report, the enforcement status report, and the complaint dismissal report, all there for you. Additionally, we added the newly adopted policy on authorized travel by agency officials, which was adopted at the BHEC meeting on August 23rd. So that is also there for you. I also went ahead and provided you all with the current licensing numbers, so you can see all the hard work that the licensing staff have been working on as well. Any questions on the reports?
No, but thank you. And thank you to our staff. You guys are doing such an amazing job as we clean everything up.
Is that everything for number 8?
That is it, correct.
Okay, number 9, we tackled earlier, so we will go on to number 10. As a quick reminder, we will tackle number 10 since this is just a note that 681.6 and 681.205 were adopted at our previous BHEC meeting and are now officially in play. We'll now move on to the additional agenda item that we added at the beginning of the meeting, public comment regarding proposed rulemaking. So public comment, you will be limited to 3 minutes. We're asking to hear from you regarding the proposed 681.140 and the amended 681.147. Christina will handle the Zoom commentary. Patrick, usual 30-second warning, please.
So anyone interested in providing public comment, specifically, this section is going to be on the rules, on the proposed rules. So if you are interested in providing public comment related to these rules, you can go ahead and raise your hand in the Zoom functions so that I can go ahead and get you speaking. The board members did receive written public comment as well related to these rules. So please understand that they do also have that. So I will start with Dr. Catherine Bacon.
Good morning, everyone. Can you hear me okay? Yes. Wonderful. Good morning, and thank you for the opportunity to provide public comment. I am Dr. Catherine Bacon, Texas Counseling Association President-elect. That sounds strange saying that for as long as I was saying liaison for so long. TCA supports the reconsideration of proposed rules related to continuing education. TCA supports the proposed rules because they establish minimum standards for quality education, provide flexibility for licensees, and align with the continuing ed requirements that have been reviewed and found to be acceptable by the governor's office for the other licensing boards housed at BHEC, which makes sense as the board's mission is to protect the public and not individuals' business opportunities. Thank you so much.
Thank you, Dr. Bacon. Okay, we also have Sandra Martin. Sandra, there you go. Yes.
Okay. I'm Sandra Martin. I'm governmental liaison for Christian Counselors of Texas, and I can make this brief. We are fully supportive of the proposals for new CEU rules. We think they help people understand who may not be that familiar with the rules. It helps them understand and see some kind of framework by looking at all of those entities that we can already receive CEUs from. We can kind of understand what's the framework, what they're supposed to look like, what the studies are supposed to look like. And so we're very happy to support the new rules. We would like even to talk about among ourselves about having more hours required of us. We feel we're getting by kind of cheap with only 24 hours when everybody else has 30 or more. So anyway, I suppose somebody will call me about that subject, but we're supportive of your proposals, fully supportive. Thank you.
Thank you, Ms. Martin.
Sandra.
Okay, then we have Ms. Smedley. I apologize if I said it wrong.
I didn't unmute myself. That's why.
There you go.
Smedley. So good morning, board and staff. I'm going to take a second longer than everyone else because I'm going to start by introducing myself. My name is Diane Smedley, and I was recently appointed as the liaison to the LPC board for Texas Association for Counselor Education and Supervision. Additionally, I come to the board as a licensed professional counselor, licensed marriage and family therapist, and a counselor educator. I do look forward to continuing the dialogue with the board as Dr. Mario de la Garza has wonderfully done. And I want to express gratitude for the work the board continues to do and the opportunity to make public comment today. Just briefly, TASIS welcomes the proposed rule changes in 681.140 regarding the CE requirements. We acknowledge the clear benefits to the CE changes, such as reduced CE burden for supervisors and the academic safety net this change creates for counseling-related degree holders. We did have a quick question, though, requesting some clarification respectfully, as it appears that the CE changes will render the jurisprudence exam as optional at renewal. And so TASIS was respectfully requesting any clarification on the role, if any, that the jurisprudence exam will continue to play as part of all levels of both licensure and then renewal. Other than that, TASIS, again, we thank you for your time and commitment to counselors and Texas citizens. Thank you.
Thank you. Okay, and last I have is Miss Rhonda Kimball.
Hi, good morning, everyone. Can you hear me?
Yes.
Yes.
Okay, good. Just want to speak to the CEs. Number one, I don't agree with any of the changes. I think 24 is sufficient, especially when you get into the financial burden for, say, a single mother who's trying to make it as an LPC. I think limiting, especially to government office approval, presenters worries me. I like the playing field a little bit more open as a Christian counselor. So I think it's kind of overstepping when we say who can provide the CE education. I think if we go back to the academic responsibility in educating at the master's level, some of the cases earlier prove that the ethics are weak at the master's level, and adopting K-CREP where everybody has to be a doctor, all these rules, and then we have to keep up with them. And then they may or may not be approved when we hand them in is just cumbersome. It's ridiculous, and we can't serve the public. A lot of these things are not working. The education that's in place and government supervised education, I mean, come on, suicide is up, depression is up, anxiety is up. We need to serve the public. And I don't have a big title or any big association backing me. I just give affordable mental health care for Christian people. And I don't want the homosexual agenda pushed on me, this critical race theory. Again, as I shared with the executive board, I'm an American Mexican. I don't like white people telling me what diversity is. I don't like people telling me that have not even paid into our government or this society that they have equity. I want to serve my community. I want to do it on my timetable with my finances, and I don't need to be told anymore. And like I said to the executive board, the day you all pay for my CEs is the day you can tell me what to do. But so far, no. I've paid for my education. I will pay for my continued education within the scope of my practice. And with the Christian community, that's what I choose and whom I choose to serve. Thank you.
Thank you, Ms. Kimball. Okay, looks like we have two more, unless more hands come up between now and then. Next one we're going to hear is Dr. Kathy Ibanez Llorente.
Thank you, Christina. My name is Dr. Kathy Ibanez Llorente. I'm an associate professor at Texas State University. I'm also a licensed professional counselor and board-approved supervisor. I would like to commend the board for bringing these proposed rules back on continuing education as they were proposed. I will tell you that students, as they've gone through their graduate training and we explore continuing education for them as future licensees, for many years have been concerned by the fact that there wasn't any specified number of hours in the area of diversity and cultural competency. So that is absolutely a welcomed area to now be included. And it seems that the changes in these rules for continuing education have actually become a little more lax in some respects. So I see it providing less restriction in some areas, which is okay. But one of the other areas that I am appreciative of is the fact that there seems to be more accountability for continuing education providers that is being requested within these rules. And so having specified providers within certain areas will provide a level of accountability for continuing education providers that may not necessarily have been meeting standards prior to today. Similar to the liaison for cases, as they mentioned earlier, there didn't seem to be a really clear specificity on whether or not the jurisprudence exam would continue to be required. My opinion is that it should continue to be required for all licensees, including renewals, as a way to ensure that all licensees are continuing to review the rules at least once every renewal period. I would just like to thank the board for your work, your continued work in providing not only protection of the public for Texas, but also the professional standards set for licensed professional counselors in Texas. Thank you.
Thank you. Okay, looks like we have a couple more. Next we're going to have is Philip Crum.
Good morning. This is Philip Crum with PracticeMentors.us. I completely agree with Dr. Chris Taylor's earlier statement that a licensee is responsible for reading the rules and following them. To that, I want to add that that applies to licensed board and BHEC council members as well when considering the adoption of new rules. In reference to the proposed CE rules changes, our thoughts on this topic are readily available in online posts and many written submissions, and that brings me to my request today. I would like to request that if you, as either a professional or public board member, haven't read every written submission on this topic generated for this board meeting from all parties, I'm requesting that you should, if this item should get to an approval vote today, that you respectfully abstain from voting on the topic until you've done so. A couple of final points, and my time is short today. The association reps keep repeating that the board has no obligation to small business. If they'll read their rule books, they'll see that BHEC and the boards do indeed have a legal obligation to consider and protect small business. We've gone into great detail in our written submissions, so I'll refer back to that. Read your rule books. Number two, I wonder how the associations would feel about all this if they weren't on the approved provider list that they just created. And number three, I'd like to hear some discussion about this amongst the board about the rules I'm referring to during this board meeting before you get to a vote. And finally, to anyone else who's listening and thinking about speaking up, please hit the raise hand button and say what you believe, even if it makes your voice shake. Thank you.
Thank you.
Mr. Crum, I'd like to be abundantly clear with you and everybody else here. As Dr. Amuna has said, I've spent the past 7 years of my life reading documents for free. And I spend hours and hours and hours doing it.
Is there anyone else interested?
One
Uh,
more.
Next we have is Dr. Lakeisha Easterling, sorry.
Dr. Easterling?
Hello, can you hear me?
Yes.
Yes.
Very good. I apologize. Anyway, I just wanted to speak. First of all, I want to say thank you to the board. And I want to say thank you to the board for just representing us, because one of the biggest things that, it's a conversation piece out here is, do we have anyone speaking up on our behalf as licensed professional counselors, and what is being said? Like, we always feel like, there's a lot of conversation about, are we being left behind in regards to like those people who are a little bit are social workers and things of that nature. So I just want to say it's an honor to kind of be here in the midst of individuals who are making decisions and just advocating on our behalf. Now, I also want to just speak up on two things, and it's very short. The first thing is concerning the CEUs. 24 hours, that's not, that seems fair. But the thing that I really want to speak on is the jurisprudence exam. I don't think it should be taken away. I think that if there's going to be an option, I just would like to offset the cost. Instead of having to pay for it, why don't we just make sure that we have it available just for those people to have it as a review when we go through to kind of get our license renewed? Because I think that and I hate to say it this way, but it actually prompts you for things that you may have missed, that you need to go back and check on, as you're out here in private practice. So that's all I have to say. And I thank you for your time.
Thank you.
Thank you, Dr. Easton. We've got one more.
Ms. Van?
Yes, I do want to thank the board for all of their work. I know that this is a very tedious job, to say the least. And I do thank you for reading my 7-page letter, sort of mini dissertation on my thoughts about the proposals. The one thing I did fail to mention is that with the jurisprudence exam, I do agree that we need to continue to have it. My only thought is, could we please make it a pass-fail? I think that oftentimes because it's a no-fail exam, people do not take it as seriously. So that would be the only thing I would like to throw in as a consideration, is that we do have some level that qualifies as passing. Thank you very much.
Thank you, Ms. Van.
Okay, board, let's begin the discussion of the proposed changes. I'm going to start off with Daryl, jump in here if I leave something out. Just procedurally, why we're here where we are right now. I would offer up the proposed rulemaking as a good example of the BHEC LPC board relationship system working correctly. If you'll recall, board, these proposed rule changes in their initial form were passed at our previous meeting. Just due to a scheduling quirk, BHEC met a few weeks after that And before that time, written submission was sent in to BHEC regarding this change. Dr. Taylor and I, prior to the BHEC meeting, went through all the written submissions, and they brought up some good points. And specifically, that was, there was concerns that independent stakeholders who provide CE services were getting left off of the approved provider list. And what Dr. Taylor and I realized in reviewing those written submissions is they had a point. And what happened at BHEC is that we requested that the rules as passed be put on pause and sent back to the LPC board for additional consideration based on what we were hearing in the written comments. And that's what happened today. Again, just due to a scheduling quirk, BHEC has met twice since the last LPC board meeting. And so at the previous BHEC meeting a couple weeks ago, there wasn't anything for us to do because this stuff was on pause. But what we were able to find out is that these rules, which in forms were being worked through our related mental health boards, had kind of undergone some additions. And specifically, the addition that we will mention today, you need to take note, now in 681.140, under the page 3 in your packet there, number 6 has been added. And this is key. It says number 6, a licensee with supervisor status is now on the approved provider list. That is a key addition here. That was done because of discussion that was taking place from LMFT and social work, and also as a way to acknowledge and address the concerns that have been brought up regarding the independent stakeholders. So the key addition now, and the difference from when we voted on these back in May, is that there has been a new category added to the approved provider list, and that is providers with licensee status, providers with supervisor status, okay? And so I view the proposed rules that we're looking at today, I view it as an improvement on what we originally passed back in May, because we are accommodating concerns that we heard, that were submitted in the written comment, that we read through, we paid attention to. Independent providers with supervisor status are now on the approved list under these rules. Okay, and that was because I would argue the system did work as it was intended to. Okay, we received written comment, we paused, we said, these are legitimate concerns, let's address them. And not only did we work through it, but also concerns that LMFT, social work, that they were hearing on their end, those were also brought up here. So what we have for consideration today is, I view it as a compromise that we added in licensee with supervisor status as part of the approved list. And I think it's a good compromise. Not everyone is going to be happy, of course. However, we are addressing concerns of independent stakeholders, but we are upholding high standards for the CEs of our profession. Y'all's profession, sorry. My bad. So I would argue that the system works, and it works well. I think that the changes that we have today, I think it's better than the one we voted for back in May. That's my opinion, but it's based on what we heard from written comment. And it also takes into account what we've just heard in public comment from our stakeholder organizations, who we granted the opportunity to let us know how they felt about the changes. Dr. Taylor, anything to add to that?
Yes, thank you. And thank you, Chair Hallbauer, that is a wonderful description of what we're voting on. I just wanted to be abundantly clear. This applies to 50%. So the other half it does allow for a normal licensee, an attorney, a CPA, all of those people to provide CEs the same that they're doing it now, the same that they're doing it now. And there's never been a discussion on our end about raising it above 24. We're not interested in that at this time. So, you know, every 2 years, half of your hours, just half, every 2 years, it's 12 over 2 years. It's one every other month. Has to come from one of these six items. That's it. That's it. So it's not a substantial change in that way, and there's still a lot of other space for free CEs from people that are not on this list, which, by the way, is a very extensive list. I mean, that covers all federal, state programs, that covers all academic programs, that covers any licensed professional counselor supervisor, of which there are several thousand in this state. That covers any professional organization, right? Not there's no identified list of you have to go to this organization. It's any professional organization. So there's a lot of space for that over the course of 2 years. So I just want to be clear on that. This is not saying that if you don't have a supervisory license, I want to be very clear, that you cannot provide CEs, because that's not accurate. You will still be able to provide CEs even without a supervisory license. You just fall into the other bucket. That's it. That's it.
Thank you. Jane, go ahead.
Well, I was also just in reading several of the comments, it's stating that LPC supervisors are not going to be required to have 6 hours of supervisor training, and that's not what this rule says at all. It's so 681 140B, special continuing education requirements. A licensee with supervisor status must complete 6 hours of continuing education and supervision. So those who were concerned that we're having less training for supervisors, that's not what the rule reads. So just wanted to point that out. There were several comments about that.
Go ahead, Dr. Bradley.
You're out.
My computer wasn't wanting to unmute me for some reason. One of the questions, and some of these questions were in the comments too, and they've been raised, but I made a couple of notes, and one is about what's planned for the jurisprudence exam. I personally think that's important and necessary. If you think about the problems that people have, they're always, not always, but often they're around this area. I agree that students should get this when they take an ethics course, but I think it's different when they're a student enrolled in an ethics course. You know as well as I do, the grade is looming out there. But what happens when they implement this ethical training into practice? I think sometimes that's where they need a little additional training to be sure, for example, that they understand Texas state law. And the other second area that I noted on my notes was self-study. I don't know exactly how to do this, but I know what I'm thinking about. I think this needs to be specified. For example, you know, what are the parameters around self-study? May I read a book, for example, of my choice? You know as well as I do, some of those books pertain and are better to help people in counseling. Now, I'm not suggesting a list of books, but maybe a category of self-study. So those were my two issues: the jurisprudence exam and how to self-study.
Dr. Bradley, the self-study is, I think, answered in H5, which is the maximum number of hours that may be claimed for this activity. is 1 hour. Self-study is credit that is obtained from any type of activity that is performed by an individual licensee acting alone. Such activities include, but are not limited to, reading materials directly related to the practice of professional counseling, time spent individually viewing or listening to audio, video, digital, or print media as a part of an organized continuing education activity program, or offering from a third party is not subject to this self-study limitation and may count as acceptable education under other parts of this rule.
That definition is another example, like Chair Hallbauer was talking about how the system is working. We learned from the social work board there. Social workers brought up the issue of, well, is self-study, is that going to preclude us from using these third-party programs that are self-described as self-study? And we were like, no, that's not what we're talking about. You're not limited to 1 hour. What we're talking about self-study is if you're sitting at home having a glass of wine and you're reading your journal article, you're going to get to claim 1 hour for that. That 1 hour limit, if you go purchase a program through some vendor that's on counseling, you're going to be able to claim the full 3, 5, whatever hours from that program. So self-study is just that it's what you do on your own time, independent of some organized program or offering. I recognize it is new to the profession, though. It's new to all of them, but we're trying to, through that, we're trying to capture, give you credit for some of the outside effort that we know so many practitioners do in order to maintain their competency in the profession. So we're trying to recognize that and give you some credit there. Mr. Chair, if you'll entertain me, I just got 2 other points I wanted to make, just for the board's edification.
Yeah.
The version of this rule that y'all are looking at, it actually has 2 more additions that we, again, through this whole process that we go through, Patrick and I have learned, we're like, we could probably make this rule better. And y'all are going to get first crack at one of them. It'll appear first in y'all's rule if you choose to adopt it, and that is sub K down there at the very bottom. When MFT and social work adopted their rules, we did not put a future trigger date on that 50% rule. That could be problematic for people right now. You know, the rule becomes effective and all of a sudden people are like, well, crud, I've wished you'd have told me that at the beginning. You know, they could get hung up on that now. We wanted to make sure we didn't catch you guys on it. And so Patrick developed that sentence that will put it off to a point in the future, give people plenty of time to comply with it. We'll need to go back and do this regardless of whether y'all adopt it or not. We're going to need to go back and do this for MFT and social work to fix that issue with them. And then the other one, it's just a fundamental fairness thing. And then the other issue is on up under F7. We added hospitals and hospital systems there. We felt like that was probably another reliable source for continuing education. That doesn't appear in any of the other rules. That's just something Patrick and I were kicking around, and we thought that's probably a good idea to include that in there. So I wanted to point that out. If y'all don't like it, you can redline it out. It's not a problem. But I'm going to definitely take that back to MFT and social work and psych and say, hey, we think y'all ought to include this. But it's, again, that's y'all's call if you want to do that. I just wanted to point that out to you. And then the last thing, and I'll shut up, is I will defend. I don't want anybody questioning whether this whole process of this rule came back from BHEC. That is not a sign of any kind of failure or weakness, and I will defend this board, the council, or anybody else against any accusations that is a weakness. That is an inherent benefit of being under the executive council structure. If what we're talking about in the public comments is a problem, then this whole process worked to identify that problem and get it back before y'all before we made any kind of a mistake. If it's not a mistake, then there has been no harm in having further discussion on it. So I do not want anybody, whether on the board, I don't want y'all concerned about this being some sort of negative context in your functions as a board. And I don't want the public thinking that this is some sort of, oh, they messed up, and that is not at all what this is. This is actually the system working like it's supposed to. to make sure we have the best product come out on the end of this that we can. So just know this. I mean, I will defend that process, to the very end, because I think it's working. And I don't want y'all worried about whether or not what you're doing the right thing. There is nothing inherently wrong with taking this stuff, bringing it back for discussion. There's never a problem with that. So, and I don't want the public thinking that there's any problem with that either. It's working like it was supposed to, just as the legislature intended. And I'll shut up.
Go, Patrick.
And just Daryl, maybe it might also be good to remind them that for MFT and social work, we submitted those rules for review to the governor's office, Office of Regulatory Compliance. They reviewed those rules and said they were completely within the agency's statutory authority. There wasn't a question or issue with this exceeding any sort of regulatory authority for issuance, and they saw no, antitrust, no anti-competitive concerns identified, none with the rules. So if there's any questions or concerns about those, we would plan to submit. If you do move forward with this rule, we would still submit this to the Office of the Governor to review again, but they've already done it twice for an almost identical rules. I cannot see how they would make a determination that would be any different than what they did for MFT and social work.
I lied. I'm not going to shut up just yet. One other thing in F, I know a lot of people are concerned about that's an exhaustive list, and that, as Dr. Taylor pointed out, that's only half your hours have to come from that. But remember, everybody, at number 8, if you get anybody on that list, if it's a supervisor, your employing entity, association, hospital, whatever it may be, if they sign off on it and you're not on that list, your program is automatically brought into that 50%. So if you submit it to them and they approve it, if you get the approval of somebody on that list and they approve your program, guess what? That now counts towards that 50%. So we have a mechanism built in there so that you don't have to just be on this outside list, if you will. So that we've tried to balance this competing interest. And I know there's some concern about how does this impact small business, and I get that. We do have to do a small business and rural community impact analysis. But the board, as the governor's office has said, rules like this are well within your purview. You guys are the subject matter experts on what type of continuing education is needed. And simply because a rule does affect small business doesn't mean you can't adopt that rule. You just have to try to reduce the impacts on that as much as you can. And that's what we've tried to accomplish here with this kind of an exhaustive list and the ability to bless, if you will, programs outside that list and then bring them into the fold. So if you got any questions on that, I know I did a poor job of explaining that. I think Dr. Taylor did better, but Patrick and I'll try to answer any questions you have.
Board, does anybody have an issue with the additional items, 6 and 7, supervisor, hospital system? Does anybody have any concern about those categories being added into the approved provider list?
I do not have a concern about those items.
I'll also add, I do not have a concern. Additionally, I think that they're good for providers who work within hospital systems, and they offer CMEs, medical CEUs, that then they are able to take part of, that relate to psychology and mental health, that they were not previously able to take part of and use towards their renewal.
Thank you, Dr. Amuna. Dr. Bradley, were you good with these additions to the rule, and since we voted on it?
Yes, I think I'm fine. The only question I have is how will the jurisprudence exam, what's its status going to be? And I realize that may be something separate.
I think, Dr. Bradley, just to that point of the jurisprudence, I was going to talk about it a little bit more on the agenda item for the reports, but we've met as a committee and we're working on updates and changes and looking at the questions and trying to determine what to leave out or what to include, or There's a lot of things to consider, and I hear the comments. I know about the fees. I understand we've all gone through the fees. I heard the one comment about the review, making it just a review. Is it going to be something optional in the future? I don't know yet. But there's so many things to think about with the jurisprudence. And I think the positive that I take from it is the fact that it is a review. It can be a really good review for you. Sure, we could look at the fees, but at the end of the day, I think that it's something that probably we need. And it is something that gives you that immediate update on things that we forget are important, things that we don't think about. As a board, we sit here and for years we've listened to many of the complaints that have come in. And so we hoped that the JP exam has addressed some of those complaints. Getting back to this particular rule, it's great. It allows you for so much flexibility. There are so many good things about this now. And to JD's point, sorry, I know I'm jumping all over, but I'm looking at 3 different computers here. I think it's just a matter of reading it line by line and really understanding what we're trying to say here. It's not that we're adding to, but we're giving you flexibility, and we're telling you that there are so many ways to be able to obtain these CEUs. And we want it to be less of an expense because much of it is online and free. So that even helps for the smaller towns, the smaller areas. First, I take no concern with the way the rule is proposed. And second, as far as a JP exam, I think we most likely will meet again as a committee. But we need to probably discuss a few more things in terms of fees, or will it just be renewed? Is it going to be optional? All these other things. So I hope I answered a little bit of what you were thinking about or asking.
Go ahead, Dr. Bradley.
I do not disagree with anything that you said, Brenda. In fact, the only point I was trying to make, and part of it goes back from experience, I have chaired a national insurance committee that deals with professional liability insurance. And we saw over and over and over again that the issue stems from not implementing. I'm not saying they don't know ethics, but I just think that this is something that needs enforced. I think this is an important aspect to protect the citizens of Texas. We don't want these ethical violations. And I think the jurisprudence exam, as they're beginning to go into the field and as they're beginning to renew, I think it reinforces some fundamental concepts that counselors should know and be aware and implement them accordingly. We don't want these ethical violations. And I'll mention one thing. I know there's a correlation. When I was chairing this board, we did a research study looking, as insurance companies like to know, what might be one of the causes. And we even looked to see in states that required an ethics course as opposed to states that don't. There was definitely a correlation in that states that required the ethics exam seem to have fewer ethical violations. And I can't help but think this correlation, although I haven't seen any data on it, but I think it would exist for the importance of the jurisprudence. I just don't think you can require too much. I just don't think we should ignore that or decrease that, that people, they only renew every 2 years, and that they should be up to date on ethics and the laws here in Texas.
Great.
Oh, I'm sorry. Go ahead, Jane.
In regards to the jurisprudence exam, I would like to see it moved from the may category to the must category simply because it is, one of the things that we look at is what are the violations that we're seeing? And then we tailor questions on the jurisprudence exam directly related to, trying to help educate people on how to make sure they're ethically staying in line. And some of that is documentation and just best practices, those types of things. In regard to the fee, and I remember having this discussion and I just did the math. So it's $39 every 2 years. So we're talking $1.63 a month. I don't see that as a huge burden for professionals. And I'm not discounting other struggles that individuals might have. But I don't see the fee of that jurisprudence exam really being a big hurdle. If that's the complaint that folks are stating over and over, then I don't know. I think that's maybe a discussion for another time. But in terms of the content of that exam, I think it is just critical that we actually have our professionals, myself included. I just took it in May. That's why I knew what the fee was, is I just went and checked my statement to go, what did I pay for that? To sit down for at least a couple of minutes just to sit and review those rules. I don't think this is, I just think it would behoove us to keep this in a requirement. And I, for it to be counted as one of those 6 hours of ethics, I'm okay with that. They need to take 6 hours of ethics. One of them is going to be from that exam. That's, just keep it in there.
Go ahead, Dr. Amanda.
I would just say I concur with Dr. Bradley and Janie and Brenda. I think that it should be a must and not a shall. I think kind of just with the things that we see on the board, regardless of our time and service, our tenure, our education, notwithstanding being licensed in several other states, knowing what the rules and regulations and ethics are is vital, especially among renewal. You're saying, I'm ready to enter into another phase of licensure, and I know everything that I'm going to be held accountable to, which would include the information on that jurisprudence exam. Something else that came to mind additionally was the fact that if someone has the misfortune of coming before us and it is a legal ethical issue, we can reference that exam and say, did you go through the renewal? Did you pass that renewal? These are things that were covered in your jurisprudence exam that, had you taken heed, might have assisted you in not being before us for whatever reason. So it's just another accountability, self-accountability for the individual, but also for the board in general. Dr. Taylor?
I agree. Thank you all very much.
So under the rule, where would that, instead of at H1, where would we move it to?
B. We just move it up to, it'd become B3.
Well, Daryl, couldn't you just leave it as an optional so they can still claim the credit, but then just add an A3 that just says you have to complete it, so they don't necessarily have to claim the credit, but you could leave it the
No,
format
you just move it up under B, because you want them to get an hour for it.
Okay.
Because F or H, whatever it is now, that's just optional stuff that they can do. So just take it completely out of there. It needs to be clear that it's a mandated special requirement. I guess it would be B2 and we would move B2 down to B3, but it'll go under B. That's where it'll go.
Is there any objection to that? It seems like it's a change that enjoys support, but does anybody have an objection to it? Okay, so that means H1 gets moved and now becomes B2. Old B2 is now B3, and H1 through 6 will now, everything would change to H1 through 5. Do I have that correct?
Yes, sir.
Okay, that does clear up the ambiguity that the public comment was asking about, correct? Okay. Is there any other discussion? And if not, I'm willing to hear a motion on this.
A motion that we move forward with the proposed rules as amended.
A second.
Okay. We do have a motion to adopt these rules as amended. Let's be clear on that. That did move H1 regarding the jurisprudence, that moved it over to special education requirements under B. And it does, the other difference, which is already in there, 6 and 7, which was added under F, and K, which sets the effective date. Those are the changes since we voted back in May. Okay, we have a motion and a second. Is there any discussion regarding the motion? Hearing none, I will say all in favor of the adoption of the new Rule 681.140, the repeal of 681.141, 681.142, .143, and .145, and the amended 681.147. Please raise your hand. And that is all in favor. The rules pass, and they will now go back to BHEC for their consideration. Thanks, everybody. At this point, I'd like to take about a 5-minute break, and then we will come back and start tackling our resolution on the compact. Please be back in 5 minutes.
Okay.
Hey, moving on. Next item, kind of fun for us, really, in my opinion. The subcommittee that was created to analyze and prepare for a possible Texas membership in the Counseling Compact met over the summer. We did some brainstorming, and it was all in regards to wanting to create a product, essentially. We're calling it the resolution that shows what the board believes are the benefits for Texas joining the Counseling Compact. It is not why we want Texas to join the compact, it's what we believe are the benefits. We all brainstormed our ideas, and those made it into the resolution. Everything got typed up and was circulated amongst the subcommittee. And what you have in your meeting material is the resolution as approved by the Counseling Compact Subcommittee. And what we need today is to hear your opinions on this. If you think we missed the ball on something, if you think that something is incorrect, or you believe, I think most likely you would feel as though we need additional reasons for why the Counseling Compact benefits Texas. So what I would like to do today, if possible, is we will, I want to hear your thought. Those of you not on the subcommittee, so that would be Dr. Taylor and Janie and Vanessa that are present here. because Dr. Muna, Dr. Bradley, and Brenda and myself are all members of that subcommittee, but I want to hear from y'all who may have ideas of your own for the resolution. And just so we wanted to create a product, and that's what the resolution is, because the goal here is sometime in March or April next year, if Daryl is testifying before a House or Senate committee regarding whether Texas should join the counseling compact, he's going to explain what he believes the benefits are. And if any of the elected representatives say, well, how does the counseling board feel about this? I want Daryl to be able to say they are all in favor of it. And in fact, they like it so much, they adopted a resolution explaining why they believe it benefits Texas. So that is part of the end goal for this. The other part is once we like this thing and it's approved, we're also going to put it on the website under the resource materials. So 30,000 of our LPCs, if they are wondering how the board feels about this, they go on the website and they can find out and they can read this resolution and say, hey, our board members think this is a good idea. And I want it to be very clear, not that we want Texas to join, but we believe that it has lots of benefits for Texas. So that's where we are. Janie, go ahead.
Sure. So the number one thing I would like to see, by the way, I'm all in favor, and I like your resolution. I'm trying to use your language there. The one thing though that I would like to see on here is I think the major benefit to Texas residents is continuity of care. If they are a Texas resident, they've been seeing a Texas counselor and anything, and they they drive across our state line, but they need to contact their counselor. I want them to be able to do that, and for the counselor to feel like that, they don't now have to, they need, of course, we have to be a part of the compact, and the counselors have to be a part of the compact to participate in that. But continuity of care is one of the key reasons that I am in favor of the compact.
Janie, I'd like to address that. It's almost as though you read my mind, because part two of this discussion was subcommittee. I know that we went through this and we have approved what's written here, but I can't help myself because I'm a lawyer. And since this thing was not finalized, I have a few suggestions that I think might make this thing even better. And I want it to be really great. And one of the suggestions is right in line with what Janie said. If you'll take a look at the end, it's at the top of the second page.
Right.
Under the second. So as it reads right now, it says facilitating continuity of care when clients relocate or travel. But I think that to beef that up, for lack of a better term, I was proposing, how about we consider this phrase, expansion of counseling service, including continuity of care when clients relocate or travel. So
And I'd just like to see that at the top of the list, not the bottom of the list.
Okay, but facilitating kind of makes it sound like this is something that we need to create, and that's not exactly the gist that I'm going for. So I proposed expansion of counseling service or services, including continuity of care when clients relocate or travel. And Christina's got this pulled up, so she's going to do share screen to show you what it would look like. And then Janie, like you said, you want to move that one to the top of the list?
When we're looking at how does this benefit Texas and Texas residents, I think that is the key benefit to Texas residents, is having continuity of care.
Okay. Do you like the wording with the red line right there, just having it moved up to the top.
Yes, the wording is beautiful, Stephen.
All right, so Christina, will you move that one up to the top under the section 2 list of reasons?
See if I'm doing it right.
Okay, that's how that would look now. I have no problem with that. I think it's a good idea. Now, Christina, if you go to this one that's right there, the creating ease and flexibility for counselors responding in crisis situations.
Sorry, which one are we on?
The one right there on the bottom there.
Okay.
I propose that we leave that as it is, but we just add the following, both in Texas and other member states. That shows that for compact, Texas counselors can respond to a crisis situation in another member state. And counselors in other member states can respond to a crisis situation here in Texas. It's just kind of showing additional scope for this. Any questions, any objections? Okay. And then just a couple more. Christina, number 3, after or that comma right there, licensure compacts. Just some additional clarification here. So it would now read similar to other successfully implemented licensure compacts in the state of Texas. No, that's already.
Oh.
Sorry. Just go to in the state of Texas. The point here, this is just an additional clarification that Texas is a member of some of these compacts in other psychology, nursing come to mind. So basically, it's just an additional clarification that that we have comparisons to what we're trying to do. So that's all that is in the state of Texas. Okay, and the last one has to deal with Roman numeral number 4. When this was drafted, these were 2 points that I thought were both important, but I was kind of hesitant to just make a single sentence Roman numeral. So I combined 2 important things into one sentence, and I would just throw out for consideration that we then put a period right there where Christina's at after organizations. And we make a new Roman numeral 5 and take out in. So again, these are 2 important things, and I just wanted to kind of maybe give them a little more emphasis by separating them into 2. So now we would say potential state of Texas membership in the compact enjoys broad support from the counseling profession stakeholder organizations. Okay, our membership organizations are on board with this. And then we wrap it up with board members are willing and available to serve as resource witnesses during consideration of the legislation required to join. And that's if you need additional information, we have people who are ready and willing to give you the additional information on this. So originally, as it was drafted, I sort of mashed those things together, but now separated it out. Yeah, it's not a deal breaker, but it does maybe give a little additional weight and wrap it up with, that's kind of our conclusion. Like, hey, thank you for listening. And if you need additional information, we've got subject matter experts available if you would like to speak to them. So those were proposed changes that I think makes it a little bit better, but you're not hurt my feelings if you disagree. And you're also, if you, I think the most important part of this is in the second section, where we give the reasons behind why we think this is a good idea. You know, I sort of drafted this thing from the legal perspective. You sort of lead off with saying what you believe should happen, but that doesn't really matter. I mean, everybody's got their opinion. What matters is the reasoning behind it. And that is everything in the second section here. These are the best arguments that the subcommittee came up with, and we hashed it out on what we thought was important. And the final ones that are up here addresses what each of these members had considered one of these things to be most important to them. So we put them all in there, and that's the final product that we have. So Dr. Muna and Dr. Bradley and Brenda, since you guys were all part of the discussion on this when we came up with when we had our brainstorm session and came up with this, let me know if these changes are no good, or you like them, you don't like them. Let me know your thoughts. The goal is, I viewed it as, hey, we've got a good resolution. Let's make it a great resolution. That was the objective here. This is I think this stuff adds to it and gives us an even better final product.
I completely agree. I think it shows that we're looking out for the best benefit of our citizens in the state of Texas, but that we can also be good global citizens to our partners who agree to be a part of that compact.
I also,
Go ahead, Dr. Bradley.
I don't know why I use Zoom all the time, but today my cursor doesn't seem to be getting it off. Okay, can you hear me now? Okay. I agree too. The only thing we discussed, but we didn't put it in there, should one of the first things in our list be extending the opportunity for diverse care citizens of Texas. I want to be sure that one knows that we think that this will allow better service. I also want to somehow show that it allows more diversity in service, not only in service, but for clients too. And I'm not sure if that needs to be in there. Maybe it's implied. I think that the citizens need to know that we think this will help them, that we're not just doing it for other reasons, but that we think that residents of Texas, and we've said that, that they'll benefit in numerous ways, but I want to be sure that they know that we have their best interest in mind.
Dr. Bradley, I think that first sentence, that expanding counseling services, covers that, including continuity of care when they relocate, but also for people to access, specialists who maybe are not in Texas. I think that's what I'm hearing you say, is that diversity in that, some specialization that maybe is difficult to find, that they would be able to access that as a Texas resident.
And if you all think that that's included there, that's the only thing. I'm perfectly fine with it. I was on the committee when we met this summer, and so I'm fine. I just want to be sure they understand it. And you're probably right. When it starts out, residents of Texas should benefit.
Okay. Hey, Brenda, as one of the compact committee members, what do you think of these proposed changes? Are you still good with this revised draft?
I am. I like the changes. I think, Jamie, you're right. When I look at the whole resolution, I just think of two words: expansion and continuity of care. That's it. That's the bottom line, is just, being able to expand and provide services where they're needed. And this is the time to do it. So I'm good with it.
Jenny, would you want it to say expansion of counseling services, including the protection of continuity of care, or guaranteeing continuity or permitting continuity of care? I don't know if including is the right word there.
I don't have a opinion on the vocabulary words. Anybody else?
Okay. I'll leave it as including unless anybody thinks protecting or guaranteeing or ensuring, if any of those seem to have a little more heft to them. Okay. Christine, the only other thing was changing that date at the top of page 2.
Yeah, let's see, this one here.
Yeah, that will
Okay.
now be today if we adopt.
Okay. I'm just gonna save it for now.
Okay. Okay, that's it. Those were the suggestions that I had. Anybody want to add anything? Anybody want to delete anything?
Ms. Hall, as a public member, what are your thoughts on the counseling compact and extending services both for residents and then also for Texas professionals?
She's not here. Oh, there she is. There.
Yeah. Actually, I don't have any additional thoughts beyond what has already been shared. In my limited knowledge, I just don't have anything to add or any value to bring to it beyond what I've heard so far.
Do you want me to bring it back up?
Bring it back up.
Do you want me to bring this back up?
Oh, no. Go ahead, Dr. Bradley.
We might want to bring the board up to date that there are now 17 states that have joined the compact. And I believe North Carolina was the 17th. And so it's really being accepted. It's not as the nursing compact, which has 39 states, but I think that we're seeing a lot of movement. And I know at professional meetings, this is an important topic because it's something that counselors have struggled with for years, and that's portability of licensure. And so I think a lot of people are excited and really see this as important.
Thank you, Dr. Bradley. Yeah, there's not many things that we tackle that has as much support and non-controversy as membership and this does. So, I mean, we're all optimistic about the upcoming legislative session, and I know our stakeholder organizations are preparing their plans for how we can, or how the legislature hopefully can get this passed. So Daryl, Does this, as edited, does it need to be read into the minutes before we vote?
No, sir. No.
Okay. Then I do need a motion to adopt the resolution on the council compact as amended.
So moved.
Thank you, Dr. Anuna. Do I have a second? And Dr. Bradley, thank you. All in favor of the adoption of the resolution regarding consideration of the state of Texas for membership in the Interstate Council Compact, please raise your hand. And that is unanimous. Thank you. The resolution passes. It will be memorial. Christina will make the edit. We will have a very formal looking document, and it will be part of the resource materials under our section of the website. Yes, Dr. Merritt.
Just for clarification, I have to say that Brenda actually made the motion. It was her voice.
Oh,
And so Brenda made the motion, and then Dr. Bradley's hand went up after that. And so she would actually be the second, just for a record. Like, I would not sleep tonight if I didn't make that correction.
thank you, Dr. Merritt.
But I wanted to play you for a moment.
All right, we've sort of already started this by discussion of the resolution, but we are going to get into our committee reports now, starting with the Counseling Compact Committee's report. Dr. Muna, so other than the resolution, what would you like to add?
I would say that there is nothing else other than the resolution. I know that there's a commission that's already formed, a Counseling Compact Commission, which is a national commission. And if there's a way we can just kind of keep updated on how that commission is doing, I can do that if I need to be that person. But it's interesting to see how other states are going to move with this with fire, so that we can be prepared when it gets to our state with regard to that commission representation and action that we would need to take.
Dr. Muna, thank you for mentioning that. I would say, I would offer that the inaugural meeting of this Counseling Compact Commission that you're referencing is taking place on October 25th and 26th. And you can sign up to attend virtually. And I've already signed up. It's free to join. So I will be kind of, as much as possible, monitoring their discussion and trying to identify hiccups that have come up and see how they're handling it. So if you would like to join, it is called the Counseling Compact Commission. And like I said, their inaugural meeting is coming up at the end of October. And I would encourage you to join.
And
Okay.
it's open to like public. Anybody can sign up for this. You can just go to Google and Counseling Compact. Their website comes up and there's a lot of information there. Sorry, just wanted to add that.
Do we have to worry about a quorum? Because I will be there.
No, y'all aren't gonna be there discussing board business, so.
Okay. One thing I also wanted to point it out as part of this committee discussion, if you'll recall in the resolution, we wrap that up with board members are willing and available to serve as resource witnesses if needed. I've already talked to 2 people about serving as these resource witnesses. First was Dr. Bradley. I said, Dr. Bradley, as a subject matter expert on this, would you be willing to serve as a resource witness in the event that you are needed? If there are questions regarding additional information, she is a subject matter expert on this, and she graciously accepted. And so she was our first designated resource witness. And just during the course of my work on this, I spoke with Dr. Ibanez Llorente at Texas State, who commented earlier. She is also a subject matter expert. I asked her if she would also be willing to serve as a resource witness in the event that she's needed. So they thanks to both of them for being willing to do this. That being said, I would open it up to, if you are also interested in being on our list of designated resource witnesses, people that are considered subject matter experts regarding the compact. If you'll let me know, I'm willing to put as many people on the list that are willing to serve. So Dr. Muna, if you'd like to be part of this, Janie, even you, Dr. Taylor, if you would like to serve as a resource witness. So, Dr. Muna, you would be willing to? Thank you. Jamie, it's up to you. You want to do it? Okay.
Absolutely, always available.
Okay. Brenda, you want to be available?
Yes, please place me at the very, very bottom of that list.
No,
But I'm on that list.
that's where I go. In case of, if all else fails, they get to contact me. And Dr. Taylor, you want to be part of this, or are you good?
Yeah, always happy to.
Okay. Thank you, professional members. I like the unified presentation that we have on this. So thank you for being willing to do that. That's all I have from Counseling Compact Committee. Dr. Muna, anything else to add? All
No,
right.
that is all. I just appreciate the work that we've put into this and, showing that united front.
I agree. Brenda, the Professional Development Committee report, please.
Yes. Okay, so, ooh. Okay, you may hear my dog. Okay, so just really, really quick, again, we've already talked about this earlier, but the professional committee met on July 13th, and we met just to review some of the questions that we have on the jurisprudence exam, any changes that we wanted to make. I thought Vanessa did great. She basically challenged so many of those questions for being so new to this board. So hands up to you for that, Vanessa. But nonetheless, we did meet. We talked about that. Then September the 1st, our Lone Ranger, Janie versus Janie, presented alone, but also added to the questions. Thank you for that. And so again, talking about this earlier and listening to all the comments, I personally, I still feel like the jurisprudence exam is needed. I feel like if everyone benefits from reading it, regardless of whether it's a pass or fail and it's just one that you can look up and answer to, I think you should take advantage of the fact that it is there and that it provides resources and information that sometimes we just forget. And then you go over one question, you think, oh yeah, I remember that now. So, I think it's just great. And I don't know if any of the other committee members have anything to add to that. I'll let you speak and then I'll motion for a motion. Motion for a motion.
I guess my only other comment, and I've said this before, is, I think of statistically, we have over 30,000 LPCs in the state of Texas, and we make rule changes all the time, up to and including things that were proposed today. And I'm so very thankful for we have 0.1% people participating in our meetings when we're making these rule changes. And so I go back to that jurisprudence exam being vital to including those rule changes, because then people are required to review those rule changes. And ideally, we hope that trickle down effect is it doesn't result in any kind of a violation, because they've reviewed the review rules. Even if the rule was changed, then they're able to see, oh, okay, that rule has changed. So.
Thanks, Jane. Anything else for professional development?
That would be it.
All right, thank you. Item 14 is the board chair report. I'd lead off by saying I followed up with Tim here on staff over the summer regarding the license application reviews, specifically in relation to the policy clarifications that we made back in May concerning how we evaluate certain degrees. The feedback that he gave me was that the changes have been beneficial. The review process has been improved, and the things that were getting hung up based on how we did things in the past are no longer getting hung up. And this has been a positive change for the staff. And I view that as a positive change for license approval, is a positive change for our LPCs as a whole. Regarding BHEC matters, BHEC met a couple weeks back. The fee changes that were first introduced about a year and a half ago at this point, these were approved by BHEC, and they have gone into publication with Texas Register on August 5th, and we're now calling for public comment on these. If you'll recall, the changes reduce the initial license application fee. But this is your chance, like I'm a defender of how the system works now, and the system on this is we are now in the point where we are calling for public comment based on the fact that these changes are now in the Texas Register. Also on BHEC, we started some initial discussion on the rules associated with how you include a therapist and client relationship in situations where the therapist views the client as a threat to their safety. The issue is we don't want LPCs to be concerned that they have a rules violation for quote unquote abandoning a client. And we don't want them to remain in an unsafe, uncomfortable situation because they're afraid of violating the rules. So this is being tackled at the BHEC level. I wanted to inform you though that this has come up, and I don't know if it's going to go to standardization or whether it's going to be up to each of the individual boards to take a look at their own policy. And it may not even be a situation where rule changes are necessary, but rather it's more of recommendations or guidelines. We are continuing to be in the process of updating the guidelines and helpful recommendations section of the website, and it may be appropriate there. But that is an issue that came up, and it's being looked at their level. We've received a presentation time for the TCA convention. We are going to be on November 10th at 4:00 p.m. Due to the travel policy, reimbursement is not available because the convention is in Dallas, and we have enough of our members in the Dallas area. Dr. Bradley, I know, is already attending, and she's going to be part of this panel. But I'm assuming that also because they're in Dallas, that they would be joining Janie and Dr. Taylor. Are you both have that on your schedule?
I will be there.
All right. Then since I'm also in Dallas, I'm willing to be part of this. We cannot go over 4 people because the quorum police come after us at that point. But we can have 4. If there's a professional member that wants to travel from outside the Dallas area and you're doing it kind of at your own expense, I'm willing to step back and not be part of the panel, just to defer to the professional members, and there would be, you would join Dr. Bradley, Dr. Taylor, and Janie on the panel presentation. However, if nobody is interested, then I'll join the panel presentation and referee the 3 of them. Okay, reach out to me if you want to go. And I'll wrap. This kind of getting into our future announcements and items on our schedule. But I want everybody to know I'm pretty excited about the Insights Over the Lunch Hour presentation that we have coming up on September 29th. It's going to be a panel discussion with Vanessa and Janie, and I'm joining them. I've been working with both of them and I'm excited about the direction that this thing is going. What we are presenting on concerns the considerations of a client who is seeking a holistic approach to their therapy. Vanessa is going to do a thorough job of explaining what your example holistic therapy seeking client, what are their priorities? What are their needs? How are they different from a traditional client? And Jamie is going to kind of serve as response for you as the counselor. How do you effectively counsel this type of client, still adhering to our rules, to the ethics rules, and definitely at the least, how do you provide good therapy to a client with these needs? The holistic client, Vanessa's going to do a good rundown on your typical demographics on this, but I've always viewed it as perhaps a younger client and what they want from their therapy. And really the educational value here is going to be, especially for the LPCs that have been doing this forever, how do you effectively relate to that type of client? So I would encourage all of y'all to attend the COE. It's September 29th. From what I can tell, our board is really doing the best job of putting these presentations on. I don't think the other boards are doing nearly as many of them as we are. So Vanessa and Jane, thank you for being willing to work on the materials on this. And I'd encourage everybody to please attend and support them, and you're going to learn something. So Janie, go ahead.
Stephen, I just wanted to clarify, are CEUs available to attendees? Or Christina, maybe it's a Christina question?
Yes.
Yes.
Okay. And so for all of those folks who had concerns about, and there's no cost, so this would be some free CEUs for individuals to be able to access.
Correct.
Correct. And Jane, you're a supervisor, correct?
Yes, I am.
Approved list. There you go. The system. All right. That's all I have for the board chair report. I'll hand it over to Christina.
All right. All right, so for LPC, we currently have 4 staff members. We will have one staff member who will be retiring. She's been with the LPC board for 14 years. So this will be a sad loss to us, but we are excited that she gets to start a new chapter of her life. Management is currently working to get another staff member for the LPC board right now. And then, when the other staff member does retire, we plan to also replace her. So hopefully we can get an additional person in here as management is trying to work on right now. So that's really exciting news. Staff are still sending deficiencies by email. Of course, if you don't have an email set up, you're not giving it to us, they'll have to send it by mail. Please make sure you give us at least one or the other, because if we don't have anything, we have no way of sending a deficiency. And or if we don't have your email or address, we can't send you your license. So applicants, just make sure you're completing all of the information and be sure to look for those deficiencies in your junk folder as well. It does come from a do not reply email. So just be mindful of that. If you submit your application, go ahead and check it, a couple of days from after submitting it up to a couple of weeks, just to make sure that you're not missing anything from us. Supervisors, again, you can go through the online renewal portal to add the experience hours in there, but it is very important. The upgrade process does not begin until the LPC associate goes into their account and applies for the upgrade. There's no additional cost, but that application generates the application for staff to work the upgrade application. So supervisors, LPC associates, please remember that that is very important, because otherwise if you just add the hours, there's no upgrade application started. Let's see. One big thing that we did want to just remind everyone, please allow at least 4 to 6 weeks before emailing staff about your application. The timeframes, I'm going to go over here in just a second. They're doing wonderful on timeframes, but just keep in mind that they work everything in the order that it's received. So they have the initial applications that come in, they process those in the order they're received. They also get deficiency responses. They'll get those and process those in the order they receive. So just be mindful of that. Give them a little bit of time. Email is the best way to communicate with staff using that contact us form on our website. It seems to be working really great. You can put your attachments in there. So continue to do that process. Another big thing, so again, as you guys know, staff still continue to deal with the high volume of phone calls and emails. So they're getting to them as quickly as possible. So we appreciate your continued patience with them, but please try and visit the website first, because there's so much information on the website. You may have to dig around and look for it, but there are how-tos for every process, every step, for renewing, for upgrading, for supervisor status. Every step is broken down. So Tim has worked really hard on trying to get all of that information on there. So there's a lot of helpful information. Again, you may have to search for it and you know, play around with it, but it's there. So please try and look there for your answer before sending us an inquiry about your, you know, whatever the question is. So right now, timeframes, staff are working on new applications are dated August 19th. So that's great. Out-of-state applications, August 19th as well. So again, they're working as quickly as they can. Again, making sure all requirements are met, but it is going pretty quickly. Upgrades and supervisor applications are currently on August 31st. So we're right there, you know, within a week or so, week or two. And staff, you know, kudos to them. They work really hard and get these dates and applications done as quickly as possible. Big note, if you applied before the dates I just listed off, that means you probably have a deficiency. So please go and check your emails and you know, make sure that there's not anything missing that we need from you. Related to renewals, the staff are working at the end of August, beginning of September. So that's great. Continue to upload your continuing education certificates online if you are selected for audit. We don't need them unless you're selected for audit. Just a reminder that the human trafficking continuing education course is still required. It's that 1-hour course, which you can go to the HHSC website to complete that. If you don't do that, your license will expire. If you don't get it done before, it will go delinquent if you don't do it before your license expires. So, you know, thank you for being patient with staff. They're doing as much as they can, as quickly as they can. And thank you to the board members for reviewing all of the material that you're always sent and all these committee meetings. And, you know, like everyone has been saying, I think this process is really working, having these committee meetings, then going to the board and BHEC. And it's just a second pair of eyes on everything, and everything seems to be working really well. So thank you to everyone for all that you do as well.
Thank you. Are there any questions for Christina? Okay, let's move forward with public comment.
Thank you for all you do, Christina. You and your staff are.
Yes.
Yes, Christina and her staff does a wonderful job.
Can we go ahead and do it? On the top?
Yeah, let's go ahead. Public comment.
Okay, we're gonna go ahead and do public comment now. Anyone who's interested, go ahead and raise your hand in the Zoom function. We'll start with Miss Angela Bowles.
Good afternoon, board members and staff. My name is Angela Bowles. I'm a licensed professional counselor supervisor, and I am the Texas Counseling Association liaison to the board. TCA appreciates the opportunity to make public comments and wants to thank the board and staff for committing to attend and present at our upcoming annual professional growth conference in Dallas, scheduled for November 9th through the 11th. I look forward to seeing as many of you as possible very soon. Thank you.
Thank you.
Thank you, Angela.
I will be there.
Woohoo. Okay, next person we have is Dr. Leanne Solomson. I'm so bad with names.
Solomon, that's right. This is Dr. Leanne Solomon. I'm an LPC supervisor. I just want to echo the kudos to Christina and her staff and how quickly licenses are being processed and upgrades are being processed. I've had several of my associates that their upgrade has been processed in less than 24 hours. So great work on that. I also want to let you guys know during this meeting, I've been a part of a couple of different group text threads that we are going on. And I want to tell you that we are appalled at the level of disrespect that was shown to you all by several of the people who spoke. And I know we don't have anything to apologize to you for, but just know that we don't appreciate the level of disrespect that was shown to you all today in this meeting.
Thank you, Dr. Solomon.
Thank you. Okay, and it looks like the last person we have is Professor Smedley. Did I say it right this time?
Tasis.
Yes, Tasis.
The new Tasis liaison.
Yes.
Yes, it's me again. Hi, y'all. Hello again, board members and staff. Again, I'm Diane Smedley, the liaison to the board for TASIS. I want to echo the two previous comments. We appreciate the work that the board does. We appreciate the attention you all are placed in to both streamline and be efficient and also make sure that the public is protected. TASIS appreciates all of the work the board does as a whole and within individual committees. And this is evidenced with today's participation regarding the CE proposed changes. And we previously talked about this earlier this year with the academic change proposal. We continue to desire an increased collaboration with the board for all stakeholders, specifically in regard to committee meetings. Opening meetings such as the Rules Committee offers input and knowledge from stakeholders who have a vested interest in collaboration. Furthermore, the lack of transparency continually leaves stakeholders playing catch up regarding rule changes. So TASIS appeals to the board that good rules that protect the public, come from transparency and collaboration. We respectfully request the Rules Committee become open to the public. I do appreciate the board's time, consideration of public comments, and your service to Texas citizens. Thank you.
Thank you. Okay, looks like we have one last one, which is Jan Fries.
Hi, good. I wasn't going to talk, but I did just want to follow. This is Jan Fries, the Executive Director of the Texas Counseling Association. Just wanted to follow up on the compact. First of all, thank you very much for that resolution. I think will be very helpful as we go through the process. TCA is working. We are currently in meetings with legislative offices and the leadership of both the House and the Senate to identify strong sponsors for the legislation. So we're cautiously optimistic, but it could be a tough road to hoe. I just want to have realistic expectations here. There are some folks over at the Capitol who, for reasons we don't understand, are not particularly supportive of compacts. But that said, we are in the process. We just had meetings yesterday at the Capitol to address that. I also wanted to let you know that there is going to be a legislative summit on September, hosted by the Counseling Compact folks. That will be on September 20th from 10 to 1 p.m. and then it'll be repeated again on September 22nd. And I'll send the registration information over to Christina so she could share it with you. It is a training or a presentation that is recommended for legislators, licensing boards, and so forth to talk about strategies other states have used and to get into kind of the nuts and bolts of how the compact would function. So we're feeling cautiously optimistic. And again, I also want to reiterate our support and appreciation for all the work that you do, and also apologize for those people who really perhaps don't understand that you guys are not paid, that you're volunteering your time and your service, and that you are a wonderful body to engage with. We don't always agree. I think some people think we always agree. We don't always agree, but we always have respect, and I appreciate the opportunity to dialogue with you. So we look forward to seeing you guys in November, and thanks for everything.
Thank you.
One more?
Yeah.
Okay.
Okay, so our last one, it's going to be Miss Rhonda Kimball.
I just want to, I feel like I just got spanked on that one. But I just want to say how much I do appreciate you, especially Christine, your department. I got my upgrade in 24 hours. However, I'm hoping in the future we can reserve judgment on the speakers and the evaluation of who's being respectful and disrespectful. I'm guessing that's why no other LPC spoke but me and all of these people that are in charge of committees and associations. So reserve your judgment, please. I don't agree. I'm speaking from, working in the field. And I hope you will always consider my remarks and anybody else who has the courage to speak up. And, I would like to see a little bit more participation from stakeholders. Thank you.
Thank you, Ms. Kimball.
That's it.
And there's no phone numbers.
Thank you, everybody. That concludes our public comments. We do have we need to take a look at the calendar under item 17. Specifically for, if you'll pull up the tentative meeting schedule, there's an issue with next year's version of this meeting that we're having right now, and that's the one at the end of the summer. What we don't want to have happen is what happened this year. And we had, like I called it, the scheduling quirk, where we had two BHEC meetings in between our LPC meetings. We want the LPC meetings to take place prior to the BHEC meeting. And that's why we are looking at the dates that are proposed here. Now, I remember from Dr. Bradley's comments at our May meeting that those two proposed for at the bottom there, Friday, August the 4th and Friday, August the 11th, that she has a conflict with graduation ceremonies at Texas Tech. Dr. Bradley, is that still the case? And if it is, we are going to remove August 4th and August 11th from consideration today.
Yes, August, we have 3 graduations and I don't have the August one, but it always occurs on a Friday and it's typically either the first or the second Friday.
Okay, that's what I recall, and that's why I'm saying right here, let's remove August 4th and August 11th from consideration for that meeting next year. Then I realized if we're just kind of going back up the calendar a little bit, then July 28th would be the next logical date. And it's a year from now. I'm sure you know some items on your schedule and some you don't, but board, if you know right now you have a conflict with July 28th, please speak up.
I really don't know this far in advance. I do know a vacation time is typically in July. And I just looked at the summer schedule. It appears to me that the graduation date is August 11th. But it may be that I'll just have to miss that summer meeting and you'll have a quorum.
Stephen, when is the BHEC meeting that we're trying to make sure that we're?
August 15th.
Okay.
Yeah. So Dr. Bradley, if graduation is the 11th, then in theory, at least at this point, you have August 4th available?
Yes, I've got the calendar up and it appears that it's August the 11th. So it appears. I'm not going to commit to summer. I will do my best. So I think you all should schedule what's best for everyone and know that I may or may not make that meeting.
Okay, well, first of all, I would like you to be there if at all possible. And so I'm willing to, at this point, put down in maybe in pencil for August 4th. And if for some reason you end up with a scheduling conflict, if you would just let us know whenever it came up, Daryl, how far in advance do we gotta lock these things down?
Well, there's no, I generally like to plan BHEC like 2 years out. That way everybody can plan their schedules around it. Now, if what you're talking about is in advance of BHEC's meetings, 14 days, 14, 15 days before that, that way I can make sure that BHEC's agenda encompasses any actions that y'all take at your meeting. But I think I think you'd be all right August 4th.
Okay.
That'll be fine. We can make that work.
Dr. Bradley, can we put August 4th right now then, if your graduation is on the 11th?
Sure, go ahead and put August the 4th. As I said, you know, I'm not going to commit completely, but I'll do my best. Summer is the only time I have to take, you know, a summer vacation, and I can't do it in June, so forth. Anyway, go ahead and schedule, and I'll do my best, but I'm not going to make a 100% promise.
Well, in my opinion, I think like you mentioned, you usually take vacation in July. I think that's true for most people. And so if we have one August date that at least works right now, I think that's our best bet at this point. The 11th is out and everything else is in July. So I think August 4th, at least at this point, works best. Is that all right? Okay. Then put it down August 4th. Okay.
Got it.
Board, any other items for consideration at future committee meetings? We've been through a lot, and I've got my notes on stuff that we'll be tackling in the future. Anything else maybe that we haven't talked about yet?
Just probably to Daryl, Christina, what represents a quorum? With regard to TCA, I will be there, but the question is, if we're in the same place, does it constitute a quorum even if we're not all on the panel?
I think you'd be okay if you're in the same room with 4 other board members. Just don't, unfortunately, you're not going to be able to, y'all can't talk about board business. I guess if you wanted to ask Dr. Taylor or somebody a question, you could do it, but.
Well, Daryl, I was going to say, if we have 4 professional members that'll be on the panel, my compromise was I could still go to maybe the luncheon or be in the booth for a little while, but not part of the panel presentation, and let our professional members handle the panel.
And I was okay with you refereeing. I kind of like that concept of you refereeing, Stephen, so I was okay.
The panel will be discussing board business. We cannot go over 4 people on that. But as far as a luncheon during the day or a little tour of the sites of Dallas, we can be part of that. It's once you have more than 4 people and you're discussing board business, that's where we run into trouble. So Dr. Muna, I'm happy to have you join the panel presentation, and I'll still be around. I intend to still attend the conference, but perhaps I'll hang out in the booth with Christina, or I'll go to a luncheon and try to finagle some banquet food at a TCA. Then, so this is perfectly fine with me. I think people would rather hear your thoughts on these things than mine. We'll talk about it later.
We'll talk about it later.
All
Daryl,
right.
you'll referee.
Okay, we run through the items on the calendar under 18 real quick.
Yeah. So the upcoming insights over the lunch hour, as Chair Hobauer had noted, is September 29th. I will be getting that information on the website in the next week or so, and an email blast will also be sent out. The next BHEC meeting is scheduled for October 25th. The next full board meeting after this for the LPC board is scheduled for November 4th. And then the TCA conference is scheduled for November 9th through 11th. I know TASIS is coming up, I think in February. I don't remember the dates offhand. And if any of the other associations wanted to send those dates to me for any other conferences, you can go ahead and send those in. And I can be sure to share them on our meetings. That's it.
November 4th will still be over Zoom. The
Yes.
technical components here at the new and improved mission control will not be ready by then. So plan on November 4th being over Zoom. And I'm not gonna commit to Zoom or in person for any meetings past that, but November 4th will be virtual. That's it. Anything to add to the calendar? All right. I know I say it all the time, but thank you for your service to this board. Thank you to the service to the people of Texas. We did a lot of tough, good work today. Thank you for all that you do. I need a motion to adjourn.
So moved.
Okay, I heard Janie first. So Janie with the motion, and Dr. Bradley, did you second that?
Yes.
All right. Thanks, everybody. All in favor of adjournment? Take care. Bye-bye.
Thank you, everyone.